Check 3-4. Check 3-4.
Good morning. Today is April 12th, 2023, and the current time is 8:38 a.m. This proceeding is being held in room 310 of the Governor Office Building, although there will be some participation by the commissioners via WebEx. The commission has set aside this time today for an evidentiary hearing in the matter of Union Electric Company doing business as Ameren, Missouri's tariffs to adjust its revenues for electric service, and that is file number ER-2022-0337. My name's John Clark. I'm the regulatory law judge presiding over this hearing today. I'm going to ask at this time if you have a phone on in the room that you place it on vibrate or turn it off. If you are participating via WebEx, I'm going to ask that you mute yourself unless you're speaking. If you're participating via WebEx via phone, if you need to unmute yourself, you may do so by pressing *6. Do I have any commissioners on?
Commissioner Coleman is here.
Thank you, Commissioner Coleman. And in person, we have Commissioner Kolkmeyer. Will counsel enter their appearance for the record, starting with Ameren, Missouri?
Good morning, Judge Jermaine Grubbs and Jennifer Moore on behalf of Ameren, Missouri.
Thank you. On behalf of the staff of the commission?
Thank you, Judge. Appearing on behalf of the staff, Jeff Keevel and Paul Graham, Suite 800, 200 Madison Street, P.O. Box 360, Jeff City, Missouri 65102.
Thank you. On behalf of public counsel?
Nathan Williams, appearing on behalf of the Office of Public Counsel and the public. I provided my information to the court reporter.
Thank you. On behalf of Consumer Counsel of Missouri?
Appearing on behalf of Consumers Counsel, I'm John B. Kaufman.
Thank you. On behalf of Missouri Industrial Energy Consumers? Okay, I have no one here for Missouri Industrial Energy Consumers yet, but they may still come in. From Midwest Energy Consumers Group?
Good morning, Your Honor. Tim Opitz on behalf of MECG.
Thank you, and you don't mind if I refer to you as MECG?
Please.
Thank you. On behalf of Renew Missouri?
Good morning, Your Honor. Andrew Linares, appearing on behalf of Renew Missouri, and court reporter has my information.
Thank you. On behalf of the Sierra Club and the National Association for the Advancement of Colored People?
Good morning, Your Honor. This is Ethan Thompson, appearing on behalf of Sierra Club and the NAACP, also on behalf of MCU, Metropolitans Congregations United.
Thank you. And do you mind if I refer to them as NAACP?
Please, Your Honor.
Thank you. And by way of preliminary matters, before we go on further, I believe in full disclosure, and I want to say that yesterday I had prepared and had emailed out a memorandum to the commission. That memorandum was somehow accidentally emailed to the Office of the Public Counsel as well as to Kevin Thompson of staff. The Office of the Public Counsel, Mr. Williams, alerted me immediately that he had received an email that was not intended for him, and I asked him to delete it. My paralegal contacted Mr. Thompson, who indicated he had not opened his email yet and would delete it. That memorandum just contained an overview of the issues in this case. It did not contain any commission thoughts or opinions or any thoughts of my own regarding how the case would go. All of the information that was in that memorandum is available in testimony or the parties' position statements. So if there are any questions about that, I will take those now. Now, there is a motion to strike portions of Nicholas Bowden's true-up rebuttal testimony that was filed by staff. Because of the proximity to the hearing that was filed, I will be taking that with the case. If we get to a time where we need to address that, I will address it at that time.
Your Honor, I do have two other, I believe, preliminary matters. Whenever
And I
you'd
was
like
going to get to those in just a second.
Okay, thank you.
I have one other thing that I want to go over before then. Now, on April 4th, the commission issued an order regarding load data, and there were responses to that load data that contained some charts. And I'm going to hold that up now. I assume that everybody has had an opportunity to see these. Is that correct? Is there anybody that hasn't had an opportunity to see these? They were filed in EFIS. Can someone tell me what witness will be able to explain those to the commission?
Yeah, excuse me, Judge, that would be staff's witness, Sarah Lange.
Okay, thank you very much. We'll address that when we come to it. And Ameren indicated that they had some preliminary matters. Go ahead.
Yeah, sorry to jump the gun, Your Honor. So my understanding is that for issue number 3, which was originally issue 30, which is the identification of avoided capital investments for the Sioux and Labadee coal plants, that the parties have waived cross-examination and those witnesses will not be presented. So we would plan on, as we're marking and entering other exhibits into the record, that we would be moving our witness, Matt Michaels, on that issue into the record at that time. Just wanted to clarify that.
And that was my understanding as well, and that I believe is also true in regard to Renew Missouri's witness. Is that correct? Yes. And could you speak into the microphone?
Yes, thank you, Judge.
And that's a reminder to everybody, please speak into the microphone. Are there any other preliminary matters that the commission needs to take up at this time?
Yes, Your Honor, I have a second. Oh, I'm sorry. If Mr. Kiefel would like to go first.
Well, yeah, I was just saying, related to what you just said about Mr. Michaels, there's a lot of testimony that needs to be put into the record that won't be presented by a live witness because of the stipulation which was filed a week or so ago. How do you want to handle that in terms of marking and do you want to just have exhibit lists so we have numbers assigned to those testimonies and we don't have to actually present hard copies to the reporter? Since they have been electronically filed in EFIS, or how do you want to handle those exhibits, Judge, that will be put into the record but aren't necessarily presented by a live witness?
Okay, and I'm going to start by saying I have exhibit lists from MECG, Renew Missouri, Public Counsel, and Ameren, Missouri. I don't have an exhibit list at this point from the staff of the commission. There's a couple ways we can do this. If other witnesses are going to be testifying about some of this testimony from witnesses that are not going to be appearing on subjects today, we can go ahead and enter those into the record up front. Or we can do it at the end. Is there a preference among the parties?
Yeah, I mean, I don't think the witnesses that will be testifying are fairly testifying on fairly discrete issues which aren't touched upon in the settlement itself or the stipulation itself. So I don't think you want to combine the two, really. We could put them in the record at the end of the hearing. We could put them in the record at the presentation, which you have scheduled for Friday afternoon. There's lots of ways we could do it, but I don't think you want to do it with the witnesses that will be taking the stand.
Well, I didn't think the witnesses could do it, and that's not what I was getting to. Oftentimes the parties will agree to not object and to enter stuff into the record.
Right. I think that's in the stipulation that it will be.
Okay.
So.
Well, unless you can see a reason that it needs to be in the record for the hearing and not the presentation, it would be my preference to do it at the on the record presentation if the evidence is germane to that.
Okay. Thank you.
Is that okay with everyone?
Now, do you want actual hard copies, or do we just? We've been here in the recent cases just doing the submitting basically an issue list and then the court reporter, I think, takes the electronic copies that are in EFS and puts them in as hearing exhibits when the time comes. I don't know.
The transcript gets sent to us, and then we attach the exhibits. The commission generally retains the exhibits because many of them have confidential information. We don't want that out in the wild. So those are generally retained by the commission. I will probably do it that way. Will you let me think about it and tell you at the beginning of the on the record?
Okay.
Well, before the on the record, because you'll need to know.
Because there's a ton of if you don't do it that way, we could spend hours just entering testimony.
Yeah, I have a stack of testimony on my desk, so I'm aware of how tall some of it can be.
Judge, if I may, this is Nathan Williams. I anticipated that you were going to rely on the pre-filed exhibits as the exhibits that were offered, and we would not need to bring hard copy here, for example, today. So I didn't bring hard copy this morning, so if I need to get those, let me know.
Okay, I don't have a problem with that. I think we can do it all electronically. That's one of the things that we are advantaged to be able to do now with EFS. So I am fine with that. What I will say is I know I'm going to have some questions for witnesses that relates to their testimony, so I would at least like any witness who's taking to the stand to have a copy of their testimony on them.
One other thing related to that, Judge, I don't believe you had issued an order requiring the filing of or exhibit lists, but I'll be glad to, we have one, obviously. I'll be glad to have that sent to you. Do you want me to just email it to you or send it in EFS or? Well, I've got a copy too, but I thought he wanted electronic versions.
Oh, if you've got no, I've got a paper copy. That's what I tend to mark on. If you've got a paper copy, I'll take that.
Yeah.
Your Honor, this is Ethan Thompson. I just wanted to note that Sierra Club's witness, Tyler Cummings, I believe is in the same situation as the witnesses mentioned earlier, and that cross has been waived.
And that's my understanding as well. Thank you very much.
If I may, Your Honor, on the second preliminary matter, I wanted to disclose or discuss for issue 2, which was originally 24B and is scheduled for hearing tomorrow. Ameren, Missouri wants to or moves for OPC witness Robinette to be excluded as a witness to be presented on that issue. And if I could be heard on the basis for that motion.
Go ahead.
So, Office of Public Counsel witness Robinette did not provide any testimony on the issue that remains, the continuing property record issue. Under the procedural order, all parties had the opportunity to file both rebuttal and sore rebuttal testimony. No OPC witness provided rebuttal or sore rebuttal testimony on the continuing property record issue. It would defy commission procedural rules, specifically 20 CSR 2.130 sub 7 that describes what should be included in rebuttal and sore rebuttal testimony. Notably, OPC did not ask to supplement or file testimony out of time on the issue, and if OPC had so requested, Ameren, Missouri would have objected. But it would be inconsistent with due process to allow OPC witness Robinette to testify. Ameren, Missouri, as the utility filing this general rate case, has the right to know the arguments to be presented by the parties and to mean a meaningful opportunity to cross-examine witnesses thereon. So Ameren, Missouri moves that OPC witness Robinette not be presented as a witness on the CPR issue.
Would public counsel like to respond?
Sure, we're just making Mr. Robinette available should any party wish to cross him or the commission and desire to ask him any questions to take advantage of his expertise. If no one has any questions, then he won't appear.
Okay, well, I wanted to hear the explanations up front, but I'm not going to rule on this at this time. I'm going to rule on it when the time comes, if you can renew your objection at that time, okay?
Thank you, Your Honor.
Thank you. Are there any other preliminary matters that the commission needs to take up at this time? Okay, I hear none. Now, as has been indicated by several parties, there was a stipulation and agreement resolving all but 3 issues and the numerous sub-issues that we have in this hearing this week. That stipulation and agreement has not been approved by the commission, and we're going to have an on-the-record presentation in regard to that so that the commission may ask questions about that stipulation and agreement on Friday at 1 o'clock. And so that's just a reminder for everyone. The other thing is, I don't anticipate with these 3 issues there being a lot of confidential information that would require us to go in camera. All the same, I don't know exactly what information may be considered confidential. So I'm relying on the parties to let me know if we are getting into confidential information, such as would require us to go in camera. Now, I have a list that was provided in the updated issues list indicating many opening statements on issues 1. And I'm assuming the way the parties want to do this is to have a mini opening before each issue. Is that correct?
Yes, Judge. I apparently didn't make I apparently didn't make my updated issue list clear on that, but if you look, there's a little blurb under each issue, mini opening on this issue. So yes, it would be, the intent would be to have a mini opening on each issue. But I would say that with regard to the issue set for today, there are a lot of sub-issues, and my intent is certainly not to do separate mini openings on each sub-issue, but to just have one mini opening on everything related to the issue 1, including all subparts. So it's just one mini opening on issue 1 rather than on each subpart.
And if I may, Your Honor, I believe because issue number 3 was going to have witnesses waive, cross-examination of witnesses waived, we were going to submit it based on the testimony. I don't believe that we anticipated having a mini opening for issue number 3, unless Sierra Club's counsel disagrees.
Yeah, I mean, I have a mini opening for issue 3, but yeah, I mean, I would like to give it, but.
Okay,
I think the commission would also appreciate an overview of the issue.
okay.
Because I'm hoping that we will go straight from this proceeding into the on the record, or if we finish, say, early tomorrow, that we will just take it up at 1 o'clock. It is going to be the same WebEx. Okay. And I'm sorry if I didn't make that clear, Commissioner. I apologize.
And if I may, based on that discussion, I believe MECG's witness might not be available till Friday. Is that correct?
That's correct, Your Honor. In our issues list, I guess the updated issues list, the parties agreed that they would be willing to take Mr. Chris out of order on Friday and virtually. He was previously scheduled to appear on April 4th, I believe, but since we delayed the hearing, he had prior conflicts this week, and Friday is the only day he was available to appear, and virtually at that. So I think that's probably the only issue or witness on Friday other than the presentation of the stipulation.
And Mr. Chris is a witness for issue 1, is that correct?
Yes, formerly issue 4, but it's now issue 1. So the issue that's being presented today, he's MECG's witness on that issue.
Okay, and I don't want to go back and forth, so let's just go by the updated list, issues 1, 2, and 3, which were formerly 4, 24B, and 30. So we'll just refer them as 1, 2, and 3. Are there any objections to taking MECG's witness out of order? I see and hear none. That will be granted. Now, in regards to cross-examination, do you want to go by the order of the? Well, I got an order of cross-examination. In regard of presentation, do you want me to go by the order laid out in opening?
Yes, actually, the witness list that's on page 5 of the updated list. That's how we planned to proceed from Ameren, Missouri's perspective.
I was gonna say, there is an order of cross in the updated.
I see it. Thank you so much. I had the order of cross in my notes. I did not see, so after each, you want to go with the witnesses as listed after each issue?
Yes.
Okay, we can do that. I will ask one last time, are there any other preliminary matters before we go into openings? Hearing none, I will take opening statements from Ameren, Missouri. Please. And be sure that the mic is adjusted and on.
Try not to unplug anything. Good morning. May it please the commission. When it comes to rate design, it is so important to remember that we have come a long way. As advanced metering infrastructure, or AMI metering, has been deployed and continues to be deployed, Ameren, Missouri has been able to roll out time of use rate options for hundreds of thousands of customers, providing customers with choice, convenience, and control. The company has developed a robust residential customer education and communications journey, including a bill comparison tool and multiple app interfaces. The company targets full AMI deployment at the end of next year, end of 2024, and is approximately 2/3 complete at this time. Those 2/3 of customers that have been through this journey have had rate choice. They've had time and information to evaluate and understand their options and the impact of those options on their bills. And they've by and large had a positive experience. The remaining 1/3 of residential customers should get the same experience, a consistent experience. Now is not the time to tinker with or overhaul residential or non-residential rate designs. With regard to residential rate designs, eliminating the anytime user traditional flat rate as proposed by staff would frustrate the tens of thousands of residential customers who have recently progressed through that TOU journey and chose to return to that traditional flat rate. Defaulting customers only 1 month after installation of their AMI meter, as proposed by staff, would mean that customers don't have any interval data upon which to base their decision or selection. The company recommends that the current 6-month post-AMI defaulting timeframe be maintained so that customers may be empowered to make their choice, their selection. Moreover, as referenced in the surrebuttal testimony of OPC witness Dr. Jeff Mark, the newly formed task force will likely be addressing the net metering concerns. Through Senate Bill 745 from the 2022 legislative session, Section 386.885 of the revised statutes of Missouri establishes the Task Force on Distributed Energy Resources and Net Metering, and provides for the task force to conduct public hearings and research and compile a report to ultimately be delivered to the General Assembly by no later than December 31st of this year. The report must include, among other things, a value of solar study and any potential legislative changes to the Net Metering and Easy Connection Act. Shifting to non-residential rates, as you'll likely recall, in the company's last electric general rate case, which was file number ER-2022-0340, the commission ordered a working docket be used to explore non-residential rate design so that new structures could be proposed in a future rate case following full AMI deployment. So while we've come a long way on modernizing rate design for Ameren, Missouri, there is still work to be done. As we finish up deploying AMI metering, We work with stakeholders to explore non-residential rate design structures, and we learn the findings of the task force report. Eliminating rate plans for residential customers, tinkering with residential and non-residential rate designs and default timeframes at this point would likely trigger customer confusion and frustration, create administrative inefficiency and wasted efforts, and unnecessary costs for the company and its customers, and further suffer from a lack of data and information from the collaborative process, like the non-residential rate design working docket, and/or the task force report's conclusions. Next, let's talk about class cost of service. It warrants highlighting company witness Steve Will's rebuttal point that in order for the working docket on non-residential rate design to be successful, the parties need guidance on the class cost of service methodologies. Ameren, Missouri, MECG, and MIEC have described the significant flaws in staff's unconventional class cost of service methodologies and patently unreasonable outcomes that could be produced by them, such as industrial customers' rates being over 10% above the national average, while residential customer rates would be more than 10% or 20%, below the national average. Similarly, Ameren, Missouri, and MIEC have described that the distribution plant data relied upon by Ameren, Missouri for its class cost of service study is reasonable, and staff's pursuit of ever more granular data without regard to the actual cost of obtaining such granular data and what amount, if any, benefit it would produce is unreasonable. To avoid the working docket on non-residential rate design devolving into disputes over granular data and significantly diverging class cost of service methodologies, the Commission should find here that the company's class cost of service approach is reasonable and reject staff's class cost of service study and additional demands for data. Also, the Commission should approve Ameren, Missouri's proposed two-way rate switching tracker in this case, so that going forward, the company's incentives are aligned with its customers' interests in pursuing TOU rate adoption, despite the expected revenue erosion from such adoption. Company witness Steve Wills has countered every one of staff and OPC's points of opposition on the rate switching tracker. Finally, with regard to revenue allocation, taking into account various factors, the company recommends the revenue increase be allocated by an equal percentage across all customer classes, except for the lighting class, in which a small intra-class shift is recommended. And with that, thank you for your time. I'll try to answer any questions or and/or identify any Ameren, Missouri witness.
Thank you. Any commission questions? Commissioner Holzman.
Thank you. Thank you for the presentation. Do you know if that Commission on Solar has met yet?
I'm sorry, the task force that was
yes.
created? To my knowledge, no. My latest understanding was that there were another member of the task force to be appointed, but I'm not sure.
Okay, thank you.
Are there any other commission questions? I see and hear none.
Thank you.
Thank you very much. Next mini opening is on behalf of the staff of the commission.
Judge, if I could, I'd request permission to do it sitting here because of my hip and knee issues.
That would be fine.
Thank you, Judge. May it please the commission. As an initial matter, I would just like to say that the commission can dispose of the first couple of sub-issues on the list, on the old issue list. It was 4A and 4B. By finding on issue 4D that the overall position of Ameren's witness, Mike Harding, is a reasonable resolution of the case as a matter of public policy. But if you get into the CCOS studies themselves. Ameren's study is frankly simply unreasonable, whereas staff submits that its study is the only reasonable one of the bunch. The changes, the commission is free to order an equal adjustment of the revenue responsibility of all classes. In other words, if you like Ameren's revenue responsibility recommendation, you can get there without relying on the unreliable Ameren CCOS study. Now, what makes the Ameren CCOS study unreliable? Well, before you look at the decisions made by Ameren in executing the actual study, you can start with Ameren's decision to base one of the most determinative aspects of its classification and allocation on data about how the distribution system looked sometime before 2009. The direct testimony of Ameren on this issue consists of essentially of a single sentence found on page 11 of Mr. Hickman's direct testimony, where he states that the results of a historic analysis previously referred to as the Vandis study assist in further dividing certain distribution system costs into high voltage, primary voltage, and secondary voltage categories, and allocated to the classifications, the classes accordingly. Now, in response to staff DR 565, Mr. Hickman admitted that he has no direct knowledge of the 2009 study itself, and his classification in this case relies indirectly on records which no longer exist. Now, in past cases, staff has recommended against ordering specific class cost of service allocation approaches because the best approach varies based on the data available. But in this case, we have seen Ameren continue its approach of limiting the data available in order to limit the options of approaches available, particularly in the area of distribution classification. Now, to accept Ameren's distribution classification in this case would be inconsistent with the position of Ameren's own consultant, Mr. Craig Brown, who concedes that the Ameren class cost of service study fails to comply with the NARUC manual in its classification and allocation of over $800 million of distribution plant. In this case, Ameren continues to deny access to basic information necessary to conduct a class cost of service study. In the 2019 rate case, ER-2022-0337, Ameren stipulated that it would discuss its data collection and retention practices and follow up with the parties concerning any outstanding questions. Staff would encourage you, Commission, and Judge to ask Ameren's witnesses about those items and ask them whether they know those items and have estimated them in this case. For example, you can ask Ameren today about the cost of distribution elements operating between 600 volts and 34 kV. I believe they will tell you that they don't know the cost, but they estimated them in a study relying on data from 2009 or before. Ask Ameren about the cost of distribution elements operating above 34 kV. Again, they will tell you they don't know the cost, but they estimated them relying on that study or on that data from 2009 or earlier. Now, why those buckets of costs are important is that Ameren uses those buckets of costs to decide what distribution costs certain customers should not have to pay. Ask yourself how comfortable you are relying on application of 2009 data to 2022 plant balances, particularly in light of the billions of dollars of infrastructure that Ameren has poured into its distribution accounts. On production costs, Ameren and the industrial interveners ask the commission to base revenue responsibility for renewable investments on billing residential customers for 51% of costs and crediting them with 43% of the revenues, while billing the LPS customers for only 7% of those costs and crediting them with 11% of the revenue. Rate modernization, you heard Ms. Grubbs speak somewhat about that. You also heard Ms. Grubbs state Ameren's opposition to provision of additional information or data which is necessary going forward. Looking forward, Ameren is asking the commission in this case to limit the access of the parties to information Ameren was able to make available in this case. In fact, Ameren's discussion of rate modernization in its position statement underscores the fundamental problem, or one of the fundamental problems of this case. Namely, Ameren still maintains that the class cost of service study it filed in this case is good enough to develop restructured non-residential rates in a separate docket. We simply do not believe that the study provided by Ameren is good enough. Ameren is seeking to increase the complexity of its rate structures while refusing to provide basic information necessary to meaningfully align those rate structures with the cost of serving customers. Ameren insists in this case that the flow of information not improve in the future. Ameren does not want the parties to have information about designing customer charges and facilities charges. Ameren is asking the commission to order parties to design rates assuming an around-the-clock cost of energy of 14.48 cents per kWh in the summer and 13.12 cents per kWh in the winter. That you can see on the proposed FAC tariff sheet. That may have changed slightly based on the stipulation, but that's roughly correct, while ignoring the market costs of energy and fundamental changes in the way the utility world works. Now, you again, you heard Ms. Grubbs speak about the data, and I would just say there are a number of issues in this case, and you can see it from the issue list, related to staff requesting access to information or in access to other information because Ameren was unable to provide the original information that staff requested. And whether or not Ameren has been keeping up with its obligation for providing data is one of the issues that you're being asked to decide in this case. Many of you have participated in rate school or even achieved some degree, NARUC degree in utility subjects. Ask yourself what information you would expect to have available when doing rate design. Would you think that you may need to know the cost, whether embedded cost or marginal cost or an estimate of those costs, of connecting a customer to the system when sizing a facilities charge or a customer charge? Would you think that cost should be about the same for a single-family home as it is for a gas station? Would you think that cost is about the same for a sheriff's office in a rural county as it is for St. Charles County Jail? Would you think that if a utility is able to tell the legislature exactly to the year how old they believe the assets in a substation are, they ought to be able to report to staff how many miles of secondary circuits they own and operate? Staff is open to sample data or reliance on available data where what we originally asked for isn't available. But we still, doesn't mean we can just make data up and go forward on that basis. Now, you heard Ms. Grubbs saying that staff study, CCOS study is not reasonable. Obviously, we disagree. They don't like the way the results of how staff allocated the distribution system, but staff did the best we could to make up for the information that Ameren either couldn't or wouldn't provide. You have Ameren saying staff is asking for Ameren to do complex calculations to figure out how plant and mass asset accounts is used, but at the same time opposing staff's request to create sub-accounts for items like large transformers and switches used to interconnect the Ameren solar farms and landfill gas plant. So basically, staff is asking now for a simple fix to this problem, but Ameren is refusing. You have Ameren saying on the one hand that rate modernization is imminent, but we should be using less reliable data and be making more assumptions to design modern rates using the same old approaches that we used as stand-ins for lack of hourly customer data in the past. So under the current Ameren rate structure, we must first make an assumption that all customers in a class use energy in the same way at the same times. That's the rationale for the rate designs of the LGS, SPS, and LPS customer classes, excuse me. But we say some of those customers use less infrastructure, so we reduce their class revenue requirement based on assumptions about which customers use what, but we're not sure which stuff those customers are using. Residential. We think, staff thinks, expediting the deployment of the default evening, morning savers rate is best, paired with rolling back access to the anytime rate. We also recommend that adequate information be made available to customers who may opt into the demand charge-based ultimate saver rate, and that the company not market this particular high-risk rate as a solution to the customer charge problem the company is requesting in this case. Now, the tracker, you heard Ms. Grubbs mention the tracker. The company doesn't need a tracker. This tracker is essentially the same as the rate migration tracker that Ameren agreed to drop in the ER-2022-0337 case when it chose to move forward with these opt-in rates without a tracker. The test Mr. Wills suggests in this case is that a deferral mechanism should be authorized when authorizing a new program that is beneficial to customers, but where, without the deferral mechanism in place, it could be financially detrimental to the utility. First of all, these opt-in rates are not a new program, and the potential financial detriments to the utility were known back when the utility agreed to pursue these rates back in the 2019 case. Now, if the commission is truly worried about Ameren shareholders receiving the level of revenue between rate cases that is determined in this case, the calculation would not be looking at the difference between what Ameren bills for customers to opt in, for customers on opt-in rate plans, and the same level of kilowatt hours billed on the anytime rate plan. Rather, it is the difference between the total revenue Ameren bills for customers on opt-in rate plans and the level of revenue determined in this rate case. Ameren's proposed tracker calculation is not reasonable because it will overcompensate Ameren for the revenue differential associated with increased usage due to effective energy storage. Ameren's tracker calculation is not reasonable because it will overcompensate Ameren for the revenue differential associated with increased usage due to accretive energy usage. And Ameren's proposed tracker calculation is not reasonable because it would doubly account for bill differences encompassed by the fuel adjustment clause. Because to the extent that pricing disparities in the opt-in time-of-use rate plans are intended to reflect differences in the cost of wholesale energy over various time periods, any savings actually realized are passed in part to ratepayers and retained in part by shareholders through the fuel adjustment clause. It would not be appropriate to consider the energy portion of differences between rate plan charges in calculating an avoided revenue or bill savings. Now, on the commercial and industrial rate design, there seems to be agreement among the parties that we need to restructure the SGS, LGS, SPS, and LPS rate schedules. Staff has a concrete proposal to inform customers in those classes of the times when they use energy and to gather the information that will be necessary to design rates to fit modern rate structures. Staff's overlay proposal causes minimal bill impact, but some customers still protest. While the staff's recommended time of use overlay is staff's primary recommendation, staff suggested if the commission is concerned with customer impact, a reasonable solution in this case is to simply add the information concerning energy usage per time period to the bills of these customers, and to retain that data in an accessible and usable format for the parties to use in establishing billing determinants and designing rates in future cases. I think I'll stop there, and I would say that Ms. Sarah Lange, staff's witness on rate design, class cost of service, will be taking the stand on this issue. And she's available also if you have questions, or I can take a wild swing at a question, but I would recommend that you probably should ask them of her when she's on the stand. Thank you, and I'll conclude with that. Thank you, Judge.
Thank you. Are there any commission questions? I have one question. You had indicated early on in your opening that if the commission liked Ameren's rate structure, and as for issue one, it is class cost of service, revenue allocation, rate design, and rate switching tracker. If I'm not being articulate enough or specific enough, please correct me. But in regard to if the commission likes Ameren's rate structure, you said you can get there without using Ameren's class cost of service report. Would you please explain that?
Yeah, that ties back to what I was saying also about the recommendation of I believe it's Mr. Harding, that the increase be spread as a let me get this right, equal adjustment of the revenue responsibility of all rate classes. So you spread it equally among the rate classes, simply as a matter of public policy rather than based on a specific class cost of service study. Just as policy that you could make that determination, staff would submit, if you want to go with a equal percent increase.
And that gets you to Ameren's rate structure without using their cost of service?
Yeah, rate structure may be a bit misleading. I'm simply referring to the equal percent increase there. When I use that term rate structure, that's probably not the most precise terminology that I should use there. I apologize, but the point again was simply that you could go with equal percent increase as opposed to basing it on a specific cost of service study.
If-
Because, and like I said, in the past, staff has advised or recommended against the commission approving specific cost of service studies versus other cost of service studies because so many factors change from one case to the next, and you have to be careful, we believe, in unintentionally setting some precedent regarding, this is the type of cost of service study that should be used and no other should be used. So if that helps at all, I don't know.
It does, but it sounds like rather than relying on Ameren's class cost of service study, you're saying that the commission could get there as a matter of public policy relying on no party's class cost of service study. Is that correct?
Basically, yeah.
What evidence would the commission use to rely on to make that kind of adjustment?
I mean, it's a customer impact question, really, Judge, because there are, commission always, well, I shouldn't say always, but historically has frequently decided rate design separate, well, I shouldn't say separate, but not specifically based on a class cost of service study. Class cost of service studies are guides. They aren't mandatory direction that, you must do this based on the class cost service study. At least staff takes that position. They're roadmaps. They're not mandatory, like I said. So what evidence could, I mean, it's just public policy and deference to customer impacts and just basic economic sense, I guess.
Now, I inherited this case. This case hasn't been mine the entire time, but in the time that I have had this case, I don't remember conducting a discovery conference. I remember the parties basically before each conference indicating that all discovery concerns were resolved. Now, I know in the parties' stipulation and agreement that the parties, as part of that agreement, have agreed to numerous trackers and studies to provide certain information. If Ameren was not forthcoming with information, and you indicated that staff was willing to work with the raw data, if Ameren was not forthcoming with information, why was this not a discovery concern earlier in the case?
It's not. There. Well, I think there was one early on, Judge. But the main problem is they claim they don't have the information, or that they don't retain the information, or that they could get it, but they'd have to write a computer code and do all this other stuff. So it's not a matter of they have it in a file cabinet somewhere, or at least according to them. It's not a matter of they could just go and pull it out, but they don't want to. They'd have to. They don't, either they don't have it or they don't retain it, or and some of that is probably true because with the AMI meters, the AMI meters obviously allow you to collect data that you weren't able to collect previously, and so the issue wasn't really a discovery conference type issue. I mean, it was something where they were saying, we don't have it, or we don't retain it, or we don't collect it, or whatever.
So it wasn't a discovery issue because it would require Ameren to produce or manufacture something?
Basically, yeah,
Thank you.
according to them.
I have no further questions. Thank you, staff. Next mini opening statement is from the Office of the Public Counsel.
May it please the Commission, Nathan Williams, appearing on behalf of the Office of the Public Counsel and the public. I guess I'll start off with what you're doing in this case is establishing rates, and you consider all relevant factors in doing so. Class cost of service studies can be a relevant factor in designing those rates, but it's not all of what you look at. The current rates certainly are important, and typically the Commission's concerned about gradualism. It doesn't want to create rate shock by suddenly changing rates, which could occur if the Commission were to jump from one cost of service study to another and just rely on that in designing rates. What Public Counsel is supporting in this case in terms of rate impacts is to look at the current rate design that's in place with current rates, and except for leaving the residential customer charge at $9 and not increasing the rates for utility-owned street lighting, do equal percentage increases to all of the classes and all of the rate elements. Public Counsel supports the customers having options. UE still has not completely rolled out its AMI meters, so as part of that gradualism, we're not proposing to make any changes in what happens with regard to time of use rates. We do support keeping the anytime user rate available. We do not support MECG's optional EV charging 3M, 4M rate design, and I leave it to Dr. Mark to inform you about Public Counsel's reasons for not supporting that or opposing it. And he's also our witness on all of our rate design issues. We do oppose UE's proposal for a tracker. We don't think it's necessary at this stage. UE already has some experience with time of use rates. If it's had any real revenue erosion, it's been able to capture that and could have shown that it is a real concern. And the rate differentials in most of their rate offerings that people have adopted are not enough to have much of any kind of a real revenue impact on the utility. Also, Ameren selected plan and service accounting when it could have gone to rate decoupling and did not do that. We don't think it should be effectively insulated from rate impacts, such as the time of use rates, or for rate switching, which is really what the time of use rates issue is about. And with that, unless you have questions that I may attempt to answer, I leave it to Jeff Mark to really flesh out what you may be interested in regarding Public Counsel's input into the rate design issues.
Thank you. Any questions from the Commission? I have one question because I've heard it twice now, opposition to the rate switching tracker. Now, a tracker, is my understanding, is just a mechanism whereby you track something and the Commission makes a determination in regard to that in the future, should it choose to. So I guess my question is, with the opposition to the rate switching tracker, what's the harm in a rate switching tracker?
There's an implication that they're going to recover the dollars that doesn't exist without a tracker.
Thank you. I have no other questions.
Thank you.
Is Missouri Industrial Energy Consumers here? I called earlier. Would you please speak in the microphone and enter your appearance for the record? That would be just fine.
For the Missouri Industrial Energy Consumers, Diana Plesha of the law firm of Curtis, Hines, Garrett, and O'Keefe, representing the MIEC.
Okay, go ahead.
Okay, thank you. May it please the commission. In the commission's last order, which was really only a little more than 14 months ago in the last Ameren rate case, the commission was faced with many of the same issues that it is currently faced with here, where you had several traditional studies by very experienced experts in cost of service and rate design, including the MIEC's witness, Morris Brubaker, who has over 50 years of experience in this area. You also had testimony from Ameren's witnesses, making it very clear that the average in excess method that has been used in the past is a fair and commonly used industry standard method of determining class cost allocation and rate design. And the commission weighed those studies against a study that the staff produced, which used some very novel concepts. It was based on some data that, certainly from the MIEC's perspective and that of other parties who were looking at more traditional methods, were not comfortable with, and felt that that study wasn't supported. And you heard many arguments that were similar in that case that you're hearing today. What we'd like to point out is that we understand that the commission has all of the discretion to look at issues beyond just the cost of service study data that you have, that the commission has to make policy decisions. On the one hand, you have evidence about the system and how the system resources are allocated among the parties. There's engineering information. You have information about what other states do. All those things are important in deciding whether you have a predictable rate design in Missouri that makes it clear what customers can expect in the future, that also makes Missouri in the mainstream and not extremely outside of the mainstream by adopting methods that have not been used in other states. But the commission has to weigh, the impact on customers of whatever decision you go with. And I think that in the last case, the commission was very clear that it felt that residential customers were going through some uniquely difficult experiences. And if you don't mind, I'd like to just read a little bit of that order. For purposes of this case, the commission finds that Ameren, Missouri's class of cost of service study offers a reasonable estimation of class cost of service. However, under the particular circumstances of this case, the commission believes that aside from Ameren, Missouri's proposed adjustment to more closely balance the company-owned and customer-owned branches of the lighting class, no class rate adjustments need to be made, and the necessary rate increase should be allocated to all customer classes on an equal percentage basis in making that determination. The commission is not relying on the relatively minor differences between the cost studies prepared and submitted. Rather, the commission is exercising its discretion to look beyond the numbers contained in those cost studies to reach a deeper conclusion that people who are members of the residential rate class have already faced enough challenges in recent years, including an 8.81% electric rate increase that will result from this case, and should not have to endure a larger one. But the commission went on to say that in the future, it may take a different approach to taking the classes closer to their estimated cost of service. So in my interpretation of the commission is that it saw a unique crisis with COVID, and it did not want to make that incremental movement toward cost of service that in so many other cases the commission has made. In thinking about whether to move classes closer to cost of service in this case, I think the commission will always be looking at the class cost of service studies and then looking at the policies and what's important. And I think in this case, you have the opportunity with a smaller rate increase than originally proposed, smaller than in the last rate case, where you have a revenue settlement that takes the rate increase down to 5.1%. And this offers an opportunity for the parties to make some movement without much disruption for the residential class. But it's important for the signals to be sent, I think, to parties that Missouri has a predictable method of determining class cost allocation and rate design. That as rates are going up and as utilities are making a lot of investment, the more far apart rates are from cost of service and traditional cost of service methods, the more difficult it will be in the future to ever get close to cost of service. And cost of service is important for customers because not only does it send price signals, it also talks about how stable it is to do business in a state, especially for energy-intensive industries. It is an economic development issue because industries can locate in other states or other countries. Energy costs are an extremely important component of the cost of doing business. So if rate design is not predictable, it's not based on methods that people understand, and it becomes a policy decision to, maybe redistribute resources, for example, in the extreme, I don't think that that is necessarily in the best interest of our state's economy. We're concerned about all customers having to endure large rate increases in difficult times. In this particular case, we have a more modest rate increase, and we have a better opportunity to make a difference without any major disruption. We did take a step away from cost of service in the last case. The commission made a policy decision, but we would encourage the commission in this case to go ahead and make some incremental movement toward cost. Mr. Brubaker, who is MIEC's witness, has proposed a smaller movement based on the smaller revenue increase. And I think if the commission were to adopt that approach, I think that would be a reasonable balancing of the interests. And I'm glad to answer any questions you have.
Any questions from the commission? I see and hear none. I have no questions. Thank you very much.
Thank you.
Issue 1, opening statement from the Sierra Club. And I'm going to ask you here, I have you, you are representing 3 parties, is that correct?
Yes, Your Honor. I was gonna say if I could just make a brief statement on behalf of all 3 parties, since their positions are aligned on issue 1, if that would.
And that's what I was going to ask, because I have you listed twice on the openings. So so this is on behalf of Sierra Club, Missouri NAACP, and the Metropolitan Congregation United?
Yes, Your Honor.
Go ahead.
And for the sake of brevity, for the hearing, if you just want to ask once instead of for all 3 parties for a cross and everything, then I think that would work, if that works for you.
I will do my best.
Thank you. Good morning, and may it please the commission. The commission should not increase the monthly customer charge for Ameren's residential customers. The Missouri NAACP, Metropolitans Congregations United, and the Sierra Club oppose the proposed increase to the flat residential customer charge here because it will tend to force higher costs disproportionately onto people who use the least electricity and can least afford higher bills. These higher costs are particularly burdensome for people on a fixed income and others who lack financial flexibility. Further, the proposed increase will reduce incentives to conserve energy and will result in consumers losing control over their energy costs and options. The commission should protect Ameren's most vulnerable customers and reject the company's request to increase its flat residential customer charge. Thank you, and I'm happy to answer any questions.
Any commission questions? I have no questions. Thank you very much.
Thank you.
On behalf of Consumer Council of Missouri.
Good morning. May it please the commission. I'm John Kaufman on behalf of Consumers Council of Missouri. We have testimony on what's now issue 1, rate design, and I think that the issues that we think are most important do all revolve around an issue that the utility highlighted, which is customer control. And so we would ask on all these issues, once you get especially down into the residential rate design, that you make a centerpiece of the factors that you're considering the ability of customers to choose their own rate plan and to be able to understand it and respond to it. Also important to this idea of customer control is the fixed residential customer charge. First of all, on the revenue allocation, we support the same allocation method as OPC. We believe that the various competing customer cost of service studies can be fairly balanced in this case with an equal percentage increase. However, keeping the $9 customer charge fixed for all rate plans. That is a customer control issue as well. The customer fixed charge is unavoidable. So if you are a low-use customer, you have to pay this, and there's nothing you can really do about it as far as changing your usage or your behaviors. If you are a high user, there are many options available to you to help with your bill. The testimony offered by Consumers Counsel is from our expert, Jackie Hutchison. Her direct and rebuttal testimony contain significant information about the vulnerabilities of customers who would be impacted by these issues. And so we submit that to you and hope that you keep that into account. And if you have questions, ask her. Again, keeping with customer control as the theme, we urge the Commission to keep the anytime rate. Our testimony describes customers who are vulnerable, customers who have an inability to change their time of use rates, and if they have looked at the options and believe that the anytime rate is best for them, we believe they should have that option. In fact, we support opt-in time of use rates only. We like customers having many options, and as long as they are truly optional, that is, customers have the conscious affirmative choice to choose them, we think that those plans are great. But we are not in favor of opt-out or simply defaulting customers, forcing them onto plans that they don't like. That's not our idea of customer control. And in my experience throughout several years in several other jurisdictions, are that the time of use plans that work the best are those that customers actually consciously choose after good information, and not the plans that are forced on them. Our testimony describes customers that we've heard from who were unhappy about the simple morning rate that was an opt-out plan. So we urge going forward that the Commission try to stay consistent, easy to understand time of use plans, and if possible, please let customers make that choice. If they make that choice and decide to own it, they will more likely respond to the signals and use that to their benefit. We are also opposed to a rate switching tool. Certainly don't believe that it is necessary, and believe that these fluctuations in the rates, especially after utility has asked ratepayers to pay so much money for these AMI meters, that they should have the risk of revenue fluctuation, and there's no indication that that's going to be anything significant that we can't deal with. So we're opposed to this rate switching tool. I think that covers all of our issues, and I can answer questions, but that's all I got. Thanks.
Any Commission questions? I hear no questions. I have no questions. Thank you very much. Next up, I have MECG.
Good morning, and may it please the Commission. Tim Opitz on behalf of the Midwest Energy Consumers Group, or MECG. Issue 1 has a number of subparts, but I'm not going to address each subpart. I'm just going to approach 3 of the broader issues, which is the class cost of service study, revenue allocation, and rate design. First, on class cost of service, MECG has the testimony of Steve Chris supporting the average and excess for NCP methodology, using as the starting point for any cost of service approach in this case. This method is consistent with the statutory guidance in section 393-1620.1, sub 1, The methodology is consistent with the NARUC manual. It's consistent with national norms. It's consistent with past commission practice. And this method is consistent with the approaches of the other parties, in this case, Ameren and MIEC. The one outlier is the staff's cost of service approach. Staff's new cost of service approach would be a dramatic shift in cost responsibility to the LGS, SP, and large primary customers compared to what would be produced by the broadly utilized cost allocation methodologies recommended by MECG. Staff's approach does not make sense in the context of our embedded cost regulatory environment, and it should be rejected. MIEC's counsel mentioned the prior order in this related to Ameren, Missouri, that came out about 14 months ago. In that prior order, the commission found Ameren's A&E for NCP was a reasonable estimation of class cost of service. The A&E method continues to be reasonable, and that's what we should use as a starting point for determining cost of service. The next I want to touch on is revenue allocation. In its prior order, most recent prior order, the commission recognized that it has taken steps in the last 7 Ameren, Missouri rate cases to move classes closer to their calculated cost of service. As a reference point, that would have been directionally closer to the cost using the A&E method as a starting point. In that case, however, the commission commented that it was committed to moving towards cost of service, but that allocating the increase on an equal % basis by class due to other circumstances was warranted in that case. Here, in the current case, MECG's, Ameren's, and MIEC's cost of service results show that the LGS and SP classes provide a rate of return significantly above the cost of service level for that class. In other words, they're over-contributing. Additionally, the LPS and company-owned lighting are also paying rates in excess of their respective cost of service levels. Had the company gotten its entire requested revenue requirement increase, MECG's filed position was it would be reasonable to allocate it on equal % basis due to public policy considerations. However, we know that parties have entered a revenue requirement stipulation that is a dramatic reduction from the company's initial ask. So our default position in Steve Chris's testimony is that we should apply 30% of the difference between the approved revenue requirement from Ameren's proposed revenue increase as a reduction to the LGS, SP, LPS, and company-owned lighting based on proportional contribution of each of those classes to the overall revenue, neutral shift, and compared to the company's cost of service study. Then that remaining reduction we would apply on an equal % basis to all of the classes. There is a schedule on Steve Chris's direct testimony, I believe it's Schedule 7, that has a example of how that calculation would be done. And if you want specific details, I would encourage you to ask him how that might be done when he's available to testify on Friday. This revenue allocation approach is a gradual approach, and it's one that's less than the 50% shift that MECG recommended in the prior case. We have tempered our ask to give even more consideration of gradualism, but we still believe that we should be making some movement towards cost of service as shown by the A&E cost of service studies. Lastly, on rate design, how do we design rates for the large general service and small primary service classes is the issue before you. And it's an established axiom that rates should be collected in a manner that reflects how those costs are incurred. In other words, fixed costs, those costs that do not vary with the amount of energy, electricity generated or consumed by that customer, should be collected through a demand or a customer charge. Meanwhile, the energy charges or variable costs should be collected through energy charges. This is not what is happening with the LGS, SP, and SP classes. MECG, again, proposes to make some gradual movement towards that cost incurred versus cost recovered basis. And again, this is tempered from our last recommendation, which is to increase the summer and winter demand charges for LGS and SP by 1 1/2 times the approved percent class increases. Meaning, once the revenue is allocated to the classes, for the LGS and SP classes, a larger portion of that increase would be applied to the demand charge rather than equal to the demand and equal to the energy charge. Again, I want to reiterate, this does not make full movement towards collecting fixed costs through the demand charge, but it is some incremental and gradual process, and we'd like to see that movement in this case and in future cases, of course. I do want to note that in the prior order, 14 months ago, the Commission expressed concern about increasing demand charges due to the potential impact on EV electrification efforts. So here, in this case, MECG proposes that the Commission require Ameren to create an alternative LGS and SP EV rates for EV charging customers with load sizes that would be on the LGS or SP rate classes. This was an effort to accommodate that concern and lay it out. Again, Steve Chris testified that in his direct testimony, and specific questions he'd be happy to answer about that on Friday when he testifies. The final point I want to touch on related to rate design is that MECG recommends the Commission rejects the staff's proposed TOU overlay and commence a rate design review process within the docket that was ordered to be opened, but never was opened, I think in part due to the rapid succession of this rate case being filed for looking at non-residential customer rate design. Again, this is recommended in the testimony of Steve Chris. Doing so will give all interested parties an opportunity in a collaborative environment to examine the universe of relevant factors, inputs and outputs, and ensure that the resulting rates for future rate designs are cost-based, equitable, and just and reasonable. With that, I'm happy to attempt to answer any questions. And I do want to again note that Steve Chris will be testifying on Friday, and he will certainly answer any questions that you might have at that time as well.
Any commission questions? Chairman Roop?
Good morning, Mr. Opitz.
Good morning, Chairman.
You're going to get the brunt of my questions because they've been ruminating in my head for all the speakers, so I apologize that you are going to get the draw here. But when I first came on the commission a long time ago, I remember there was quite a discrepancy, especially on the residential class, of subsidization of rates, and it was a common argument from the industrials and the others that we're out of whack. And I remember us taking active steps each rate case to bring that closer to the cost of service. I also remember that we deviated from that in the last one due to the extraordinary events of COVID and everything that is there. That being said, I had thought we had gotten pretty darn close to relative, of rates reflecting the class cost of service. Now coming to understand that depending on who you ask now, because everybody has a different class cost of service study, you're going to get varying answers. But looking back at the previous case and the previous cases before that, how far away are we, based off of the A&E and the previous class cost of service studies that we relied upon, are we from parity in the different rate classes?
So with respect to a specific number, that would be in the testimony, and I don't recall off the top of my head, and I don't have it in front of me. That would be in the direct testimony of Steve Chris. in this case, and I believe it's Table 3.
Table 3.
If I'm remembering correctly, it might be Table 4. And he talks about basically how much each class is contributing to the rate of return. And anything higher than 1 means you're over-contributing. Anything lower than 1 means you're under-contributing. So that would...
And he based that on?
That's based on the cost of service study using the average and excess for non-coincident peak methodology, which is very similar to what Ameren uses and MIEC uses.
And that's
I think it
similar
might be exactly the same, but
And that's similar to what we relied upon in the previous cases.
in the most recent case, the commission said that it was a reasonable estimate of it, the A&E method, but deviated from it for public policy purposes. It's my view that, and I believe Steve Chris's testimony in the prior cases has been using this A&E methodology. So from our perspective, when we're advocating for shifting away from that, I think you called it subsidization, that's occurring, which is, in my view, basically the LGS, SP, and LPS classes over contributing their share, I would say yes, it is comparing to that A&E method throughout that. I don't have perfect memory of all of those prior cases.
Not asking you to,
So,
just.
yes, I think that's what we look at, the industrial customers. I think that's what the utilities have looked at. I think this is pretty close to what Evergy has used in the past and pretty close to what Empire uses, the same cost of service study methodology. And each utility has had various reasons for whatever revenue allocation they recommend. You may recall testimony in the Evergy case. Evergy wanted to make shifts to adjust, to accommodate some gradual shift away from the classes that were overpaying. Here, Ameren was saying, let's do it equal again. If it was a $316 million increase, MECG was willing to accept that equal allocation subject to the lighting adjustment. But since there is a reduction, which is mitigating the impact to, I'll call it the classes that are under contributing according to the A&E method, then we think there should be some movement to get to the cost of service. And again, I'll say we have tempered our request in this case compared to the last case. And I'll say, you know, it is in part due to the guidance from the commission, or what I perceived as guidance from the commission, you know, that it was concerned about these external factors, thought the 50% movement was too much. Obviously, here, you know, I think on Monday there was some rescission of all emergency COVID orders, something like that. But, you know, we're out of that emergency, from my view. And, you know, but even in consideration of any lingering effects, we did temper our shift that we're asking for here.
So is it an overall general concern is that we were making consistent progress through rate cases for the last 9 years, at least I can remember, of getting closer, and due to the public policy reasons of COVID and everything from the last case, that if we don't continue making gradual steps towards class cost of service study, that the default would be, you know, 2 rate cases in a row of an equal percentage shifting, and that would become the new precedent?
I think there's some concern. We were making consistent progress. I think in this case, there's also an even broader issue, which is, you know, we have the company, we have MECG and MIEC putting forward one method that is used nationally, that is consistent with the statute I referenced, consistent with the approach I believe the commission has taken in the past, compared to this new approach by the staff, which is, I believe if you use their approach, it's going to have a significant shift. I think their approach would show, and I'm not endorsing it, but using their methodology, industrial customers are the ones who are being subsidized under their method. We disagree with that, but so it's would totally flip the progress that
MECG would argue has been made, save the last case, towards getting the cost of service to say, well, wait a minute, if we use staff's method, we've got to flip it and go backwards the other way. I'd urge you to reject that. I don't think it's appropriate in our vertically integrated environment here in Missouri. Steve Chris would be happy to talk about that. He talks about it's not appropriate in an embedded cost environment. Staff's methodology.
Bringing up what Ms. Plesher brought up about, what did she say? She just referenced the previous case, and staff's class cost study was, I think she used the word novel. But are we going to continue to have this argument every case until we kind of come to some determination on class cost of service studies and how and what we should be using and really make a definitive policy statement on this is where we want to go? Because it seems like staff's going to continue to try to do some novel approaches and look at things, and the status quo is going to be using the A&E, going back to the multi, and we're going to continue to have this argument. So at what point do we just throw down and dive into a class cost of service study parameters that we want to be using as a commission?
I'll say that the way our regulatory environment is structured in Missouri, I think it's safe to say MECG would always be supporting the A&E method for a class cost of service. So if the commission were to endorse that, we wouldn't shed any tears over that. I'll caveat that to say some things do change. I don't know, if there's some legislative change, where we're deregulated in Missouri, something like that. That might change the cost of service approach that certain parties recommend. I don't think that we're there yet, but I guess the main point you're asking is, are we going to see this argument in every case? And I would say it's likely if the commission doesn't offer some firmer guidance or some direction about, what approach it thinks is most reasonable in this case. And again, I want to caveat that say, when you have a new case, you're looking at everything anew again as well. So you're not necessarily binding everything, but I think that would give parties some idea of feedback of what the commission is looking for. Again, I noted a couple different positions that MECG has taken in this case, not that we were required to, but to temper our approach to satisfy some of the concerns of the commission. So if the commission is concerned that parties are too divergent on which class cost of service approach is appropriate, I think some guidance is helpful there. But, I can't control what parties are going to recommend.
True. Thank you for indulging my questions there.
Happy to do it.
Sorry you got the brunt of them all.
Thank you.
Thank you, Your Honor.
Renew Missouri.
Good morning. May it please the commission. In this case, Renew Missouri is asking that the commission take some steps to ensure that Ameren, Missouri allow its residential customers with solar and battery storage to participate in the company's rate design options. Specifically, we're requesting that the commission order Ameren, Missouri to conduct a study on integrating distributed generation technologies with time of use rates. In addition, it's worth mentioning, Renew Missouri opposes Ameren, Missouri's proposal to increase the customer charge from the existing $9 to $13 for most of the residential customers. And we request that the commission issue an order maintaining they charge at $9. Okay, so we find ourselves in a strange situation here in this case. An electric utility has developed new rate options that purport to be about, number one, reducing peak demand by shifting load from off-peak, from on-peak to off-peak. Number two, giving customers more control over their energy and their bills. And number three, encouraging adoption and integration of distributed generation on the grid. That's what these time of use rates are purported to be about. And yet those rate options are explicitly unavailable for customers that possess the very technologies that accomplish these goals most effectively. So we're talking about PV, rooftop solar, and grid-tied battery storage here. Ameren, Missouri seems fairly determined not to take on the task of integrating these technologies with its new rate design tools, citing legal grounds as the reason why Ameren can't accomplish this integration. But as I'll discuss a little later, we believe that this reason neither holds legal merit nor explains the inaction by the company on this issue. More likely reason is a concern for revenue erosion and loss of resource control as distributed generation adoption increases over time. So the relief we are requesting in this case has a very recent and analogous precedent. In Evergy's most recent rate case, I believe that's ER-2022-0129 and 0130, the commission approved a stipulation and agreement containing a term that says the company will develop a report that examines the technical, billing, and legal barriers to offering time of use rates to residential customer generators with net metering or interconnection agreements. This report shall also explore potential solutions to the barriers identified. The report shall be shared with the signatories to this case and other interested stakeholders before the filing of the company's next rate case. So that's from the recent Evergy rate case. That's essentially what we're asking for here. We're asking for this order for two separate but compelling reasons. Number one, Ameren, Missouri has an obligation to provide the same rates to solar customers under the Net Metering and Easy Connection Act. That's 386.890 in the revised Missouri statutes. And number two, integrating solar and battery with time of use rates serves desirable policy goals. And in fact, these are some of the very same goals that time of use rates purport to serve. So we have a legitimate legal dispute in this case that I believe is properly sorted out by the commission. Renew Missouri believes that the state's net metering statute, the Net Metering and Easy Connection Act, confers an obligation on Ameren, Missouri to offer the same rate options to customers taking service under a net metering tariff. Ameren, Missouri, on the other hand, argues, and you can see this in Mr. Will's testimony, that the net metering statute prevents Ameren, Missouri from offering time of use rates to net metering customers, even if the company wanted to do so. So here it's useful to actually look at the language in question. And the statute holds, quote, a retail electric supplier shall, and this is parenthetical 2, offer to the customer generator a tariff or contract that is identical in electrical energy rates, rate structure, and monthly charges to the contract or tariff that the customer would be assigned if the customer were not an eligible customer. Okay. So first, what I'd like to do is dismiss the idea that the company's prevented from integrating time of use rates with distributed generation, or specifically net metered solar. We'll talk about batteries in a second. So although the net metering statute might not have contemplated time of use rates back in 2007 when it was passed, there's no language here preventing a utility from electing to do so. We can see this by the fact that many utilities have figured this out in the Southeast, in California, and other places, and they have substantially the same net metering framework. Moreover, Ameren, Missouri has already proved that this is possible in principle. They've defaulted AMI customers to the evening morning saver rate, which is a time variant rate. So Ameren offers an explanation that the price differentials there at the evening morning saver rate, they're negligible, they're not a huge impact, so they're not concerned about it. It's of small enough concern that's, not a concern to the company. So I just note that this is merely a difference of scale and of degree here. The fact remains that it's possible to integrate a time of use rate with a net metering tariff. So rather than whether it's legally possible here, the issue is whether Ameren is required by the statute to offer the same rate options. So I just draw your attention to a couple of the words there, offering my legal opinion why I do think that that's a requirement. The statute states that customers must be offered identical electric energy rates and rate structure, the same electric energy rates and structure as non-net metered customers. So to me, the clear intent here is to not punish customers for investing in solar and conferring those benefits back to the grid. To my reading, these phrases, they indicate that solar customers should have the same rate design, including all the options, as other customers, and thus they should have access to time of use rates if they're offered. Ameren focuses instead on the word assigned here to conclude that customers need only be given the same default rate. So if there's other opt-in rates available to non-net metered customers, that still meets the dictates of the statute. However, the statute also uses the word offer, as I said, which to me implies the ability to turn something down. That's what an offer is. You have a choice. Hence, a series of options. So ultimately, the commission here has to decide whether the phrase is identical rates and rate structure, whether those logically include the same rate design options as non-net metered customers, or instead whether the word assigned there means that the customer only has to be given the same default rate and there's no obligation to offer options. One important thing to note here is that this whole legal dispute that we're having, it has no bearing on battery storage. The company is free, is certainly not bound by the net metering statute they're not restricted from offering a time of use rate to a customer with a grid-tied battery storage system, which has a lot of capabilities for load shifting, obviously. So I believe there are really good policy reasons that they should do so, and that's where I want to turn next. Briefly, it is worth noting sort of the inevitability of a lot of these technologies. The Solar Energy Industries Association, or SEIA, they expect over 200 gigawatts of new solar capacity to be installed in the next 5 years. So for context, the total installed capacity at the end of 2022 was about 140 gigawatts. We're talking about more than a doubling in the next 5 years. In terms of battery storage, the U.S. Energy Information Administration anticipates over 20 gigawatts of new battery storage capacity installed from 2023 to 2025. That's on top of 8 gigawatts currently in operation. So these technologies are going to accelerate significantly, especially considering the federal IRA legislation, the Inflation Reduction Act, which includes expanded and extended tax credits, both for solar and for battery storage. PV solar and battery storage, these technologies don't obey linear curves. We know that, rather a type of exponential curve. And this applies to prices as well. These technologies are expected to decrease predictably in price. So even though these price curves and adoption increases are inevitable, that by no means means that the process will be smooth. For that, we're going to need planning. We're going to need intentional focus on how to integrate these technologies for the benefit of customers and for the utility and the system as a whole. That's why we're asking the Commission to order Ameren, Missouri to conduct a study, just like in the Evergy case, on integrating solar and storage with new rate design tools, like time of use rates. Otherwise, Ameren's going to be forced to confront this issue sometime at a later date when distributed generation occupies a significantly larger space on the grid. Moreover, Ameren's going to be foregoing an opportunity to utilize technologies that provide the benefits that Ameren says it is seeking with its time of use rates, namely load shifting from on-peak to off-peak, system demand reduction, and providing customers with more control over their bill. Also encouraging the adoption of distributed generation. Another note about batteries, it should go without saying, but battery storage has the unique capability of being able to charge up at times of low system peak and deploy at times of high peak. Imagine a network of thousands of batteries distributed across a grid with a clear financial incentive for customers to install those and engage in load shifting behavior. This could have a significant load shifting and demand reduction impact. And solar also coincides with that pre-peak period of the day, that noon to 1 period of the day, and can be used in combination with batteries to exaggerate that effect. So in my ideal world, I'll make no secret of the fact that I'm a battery and a solar advocate myself, and Renew Missouri is as well. We would love utilities to own and operate gigantic fleets of batteries and solar panels, having the ability to balance the grid and optimize voltage down to the local node and even the meter level, replace the need for natural gas peaker plants, et cetera. But I recognize that there could be a huge short-term rate impact there that might not be feasible. So the next best thing, short of that, would be to encourage customers to spend their own money installing these technologies, sparing ratepayers by taking advantage of that customer investment. And one way to do that, one way to encourage that, would be through a rate design that rewards customers for charging it off-peak, deploying it on-peak. In other words, a time of use rate. Some might call this gaming the rate by using batteries and solar. Others might call it appropriately incentivizing a customer for providing superior value to the grid that the utility is currently failing to provide. Regardless, the Commission has a decision to make about whether to protect utility profits at all costs or embrace growing technologies for the unique value that they can provide for the entire system. Last couple points I want to make here on the time of use rate question. In Missouri, we're rarely breaking the mold on new rate policy. Perhaps it goes back to our state motto. But we're typically waiting for other jurisdictions to provide the case before pioneering into the unknown or whatever. And thankfully, we're able to do that here as well. Both regulated and deregulated states have successfully integrated net metered solar and time of use rates without too much difficulty. We can look at Dominion in Virginia, so southeastern state, regulated market. They've managed it. Starting in 2001, they began an experimental rate option called the off-peak plan. It's available to both net metered and non-net metered customers. Over 10,000 customers was their limit. They reached it very quick. The company there solved the problem, which I want to give Ameren, Missouri some credence here, some credit. There is a problem of how to offset kilowatt hours. Which kilowatt hours do you offset, the on-peak or the off-peak? And they solved this problem simply by saying that during a particular period, you can only offset consumption during that same period. So if you've offset off-peak kWh, you can only get credit for off-peak kWh, and same for on-peak. This solution, South Carolina, Duke in South Carolina, employed kind of the same compromise there. So this solution would be in keeping with the Missouri statute's use of a one-to-one credit paradigm there in the net metering statute. In addition to these two southeastern states, California requires that distributed generation customers take service under a default less severe time of use rate, and they can elect for a more severe time of use rate. So it's been done out there. It's been done other places. So I just want to get that on the record that this is not something that we're forging a new path on. This has been done. Very briefly, the customer charge. It should come as no surprise, Renew Missouri joins other parties in imposing an increase here. I'd like to point out again, Mr. Will's testimony for the company. He repeatedly states that the company wants to use rate design to allow residential customers more control over their bills. And in that same testimony, he proposes an increase to the customer charge, decreasing the volumetric portion of the bill, which I think does precisely the opposite. It discourages DG investment. It discourages conservation and energy efficiency. And I'd also like to push back on the company's claims that the impacts on low use and low income customers would be negligible here. We don't agree. A customer charge increase would set a precedent and would likely lead to further increases over time, eroding customers' ability to control their bills. And, moreover, there are several parties in this case for whom this is the overriding issue. They've decided that potential impacts from the proposed increase is worth their time to oppose. So I wouldn't say that the impacts are negligible. So to summarize briefly for you here, regardless of the way the commission decides the issue of statutory interpretation there regarding the net metering language and the time of use question, we can still chart a path forward for using rate design to encourage distributed generation technology like solar and batteries. So we ask that the commission order Ameren, Missouri to conduct a study on integrating distributed generation technologies with its time of use rate options and to present that study to stakeholders before its next rate case. So we have the testimony of James Owen, the rebuttal testimony of James Owen in this case pertaining to these issues. More information can be found there. It's offered as Exhibit 450 in this case. All the parties have agreed to waive Mr. Owen's cross-examination. I understand the commission has no questions for him. However, I am here and available for questions if I can be helpful. So I thank you and offer myself for questions.
Commissioner Holzman.
Thank you for the presentation. You asked for us to approve a study for Ameren to do. What would be different information in that study versus what was presented earlier with the task force that the legislature is currently undertaking?
Yes. Yes, so in both Evergy and Ameren, and first of all, I don't think anyone has any, if we wanted to combine these into some single proceeding or some single workshop, I think that would be fine. But this differs from the net metering task force in that I don't believe the legislation authorizing that task force mentioned the issue of time of use rates or any rate design working alongside net metered solar. So that's the issue we'd be injecting here is how do we integrate those two concepts? How do we use rate design to encourage distributed generation?
Okay.
Yeah.
And you read the net metering statute that says that they're required to provide the same rates as if they had not installed
Yes.
a distributed generation system. I know that in previous discussions, it's been talked about if a time of use rate was provided, but maybe not all of the time of use rate options. Is that something that you would find satisfactory if there was a distributed generation time of use that would address some of the concerns that the company might have? Or are you suggesting that the statute says that every time of use offering to every customer should be offered to every distributed generation customer?
Yes, that's a good question. Well, I think I'm saying a number of things here. So there's a legal issue, but then there's all the other policy reasons. As I explained, I don't believe the company is prevented from doing this, even if your decision is the statute doesn't require them to offer all the options. I think there's the company's able to do so, but in terms of the first issue, whether they're required, yes, that's the legal argument we're making here. I believe rate options, all the same rate options, is included in that phrase, the same electrical energy rates and rate structure. I mean, I think the same offer should be made to net metered customers as all the other customers. That's what I think is consistent with the language there. But again, aside from that issue of whether they're required, they're able to do so, and I think there's good reasons why the commission should encourage them to do that.
But then the second part of that question is if they designed or if they
Yes.
offered a rate that was for net metered customers that may not encompass all of the time of use rates, would that be something that your organization would be in support of?
Of course, we'd be willing to engage in that as stakeholders and include the solar industry in that conversation and solar customers. Yes, I think that's something we'd be open to. I mean, I think the key here is our utilities in Missouri should be using rate design and the rate design tools they have to properly reward solar customers, to allow customers to utilize rate design to do what the utility says they'd like to do, which is load shifting, demand reduction, give customers more control over the bill. We share all of those values. We think that rate design should be doing all of those things.
Thank you. Thank you, Judge.
Thank you, Commissioner. Any other commission questions? Commissioner Kolkmar, go ahead.
Thank you, Judge. Good morning.
Good morning.
You said that there's a statute saying that all customers must have the same rate?
Yeah, I'm happy to read that for you if you'd like and clarify.
Please.
Yeah, so this is 386.890. This is the Net Metering and Easy Connection Act passed in 2007. Many states, majority of states have a policy like this. It's allows customers to install their own solar and receive credit for the excess that they put back on the grid. Use the grid as a backup and exchange power back and forth. So utilities have tariffs under this statute, and the term in there, first it says the electrical supplier shall, put in place net metering, and then the second parenthetical under that term is offer to the customer generator a tariff so the customer generator there is the solar customer. A tariff or contract that is identical in electrical energy rates, rate structure, and monthly charges to the contract or tariff that the customer would be assigned if the customer were not an eligible customer. Essentially, we don't want, the statute is there to prevent solar fees from saying, all right, if you're going to take service under a net metering contract, you owe this much, a sort of a punitive fee for going solar. That's what it prevents against.
But there isn't a statute saying that, the way I understood you when earlier in your testimony, you said that there was a statute for all customers have to have the same rate.
Well, all solar customers must be offered the same electrical energy rates and rate structure as non-solar customers.
Okay.
That's what that term says. Yeah.
Okay. Thank you. Thank you, Judge.
Thank you, Commissioner. I'd like just briefly to kind of clarify Renew Missouri's ask in this case.
Sure.
Because in this particular rate case, is Renew Missouri asking the commission to order the integration of the net metering and time of use rates, at least in regard to the reimbursement I believe you're talking about? Or are you merely asking the commission to order a study similar to what Evergy is required to do? Or are you asking both in this rate case?
Yeah, thank you for clarifying, Judge. Our desire is to move forward as a state on this issue. So I think it makes sense to move forward with what Evergy is doing. So to your question, it's the latter. We're only asking for an order to conduct a study. Similar, identical in terms of the term that was approved in the STIP in Evergy. So I hope, does that answer your question?
It does. Thank you very much.
Sure.
I have no further questions. Thank you.
Thank you.
I don't have on my list that I've missed anybody, but is there anybody who I missed who wanted to make an opening statement? I see no one. Here's what I'd like to do at this time. I want to talk ahead a little bit in the day. It is currently 10:29 a.m. I think it's a good time to take a break. So in a minute, I'm going to break until 10:45. Today is also an agenda day for the commissioners. So with that in mind, because there's some setup involved for that, I intend to take the company's first witness at when we come back from break at 10:45, but we will break at 11:30 for the agenda meeting, which is at noon, and I will probably incorporate the lunch break into that because it doesn't make a lot of sense to do otherwise. But we'll address that at 11:30. So with that in mind, we'll break until 10:45, and we are off the record. I have listed as Ameren's first witness, Witness Harding. Is that correct?
Yes, Your Honor. The company calls its first witness, Michael Harding, to the stand for issue 1, please.
If you will come up and take a seat and say and spell your name for the record.
Michael Harding, Michael Harding.
And would you raise your right hand to be sworn? Do you solemnly swear or affirm that the testimony you're about to give in this evidentiary hearing is the truth?
Yes, I do.
Ameren, you may proceed.
Thank you. Mr. Harding, by whom are you employed and what is your title?
I'm employed by Ameren, Missouri. I'm the manager of rates and analysis.
And you're the same Michael Harding who filed direct rebuttal and surrebuttal testimonies in this case, which have been marked as Exhibits 32, 33, and 34.
Yes.
Do you have any corrections or revisions to make to your direct rebuttal or surrebuttal testimonies?
No, I don't.
If I asked you the questions in your testimonies today, would your answers be the same?
They would.
I move for Exhibits 32, 33, and 34 into the record, please.
Any objections to admitting those exhibits onto the record? I see and hear no objections.
Thank you, Mr. Harding.
Hold on just a moment. I actually want to get to where on your sheet these are. And you said 32, 33, and 34, is that correct?
Yes, Your Honor. Page
Okay.
4 of our
Exhibits
exhibit list.
32, Exhibits 33, and Exhibit 34 are admitted onto the hearing record.
Thank you. Mr. Harding's tendered for cross-examination.
MIEC? Can you speak in the microphone, please?
No questions.
No, you don't have a microphone. I apologize. That's no questions from MIEC. MECG?
No, thank you, Your Honor.
Sierra Club, NAACP, Metropolitan Congregation?
No questions, Your Honor.
Renew Missouri?
No, thank you, Judge.
Consumers Council of Missouri?
No questions, Your Honor.
Public Counsel?
No questions at this time, thank you.
And the staff of the commission?
Let's just make it unanimous, no questions.
Okay, nobody has any questions for Mr. Harding. I actually have a question for Mr. Harding this
All right.
time. But I'll ask first, are there any, I know I have Commissioner online. Are there any questions from the commission? Hearing none.
No questions, Judge.
Thank you so much, Commissioner Coleman. Hearing no questions. Mr. Harding, do you have your rebuttal testimony in front of you?
I do.
On page 2 of your rebuttal testimony, beginning on line 13 and ending at line 20, you state that based on staff witness Lang rebuttal testimony, pages 52 and 53, the company does not agree and find reasonable Ms. Lang's assessment of an equal percentage increase across all classes after separately addressing lighting rate classes. Is that still Ameren's position here today?
Yes, I believe in that case she was referring to a scenario where she hypothetically agreed with our class cost of service study and in that case, she also agreed that under some of those conditions that it would be appropriate to have an equal percentage increase across the classes.
And what's Ameren's position?
Ameren's position is that we use our class cost of service.
And that's the two-step process?
That's correct, Judge.
And just briefly, would you walk me through that two-step process?
Sure. So the way we do it is we first do the revenue neutral change. And so the only revenue neutral change that we suggested in our direct was the, within the lighting class from the company to the customer. Since the customer-owned lighting class was, it did appear, at least in my opinion, to be the most unreasonably away from our equal rate of return class cost of service that Mr. Hickman had produced. So everything else then, after that revenue neutral exchange, then receives the equal percentage increase of the revenue requirement change.
Thank you. I have no further questions. Are there any questions based upon my questions to this witness? I see none. Mr. Harding, you may step down.
Thank you.
Ameren, you may call your next witness.
Thank you. Thank you. The company calls its next witness, Thomas Hickman, to the stand.
And Mr. Hickman, if you'll have a seat and stay and spell your name for the record.
My name's Thomas Hickman, Thomas. Last name Hickman, Hickman.
And would you raise your right hand to be sworn? Do you solemnly swear or affirm that the testimony you're about to give at this evidentiary hearing is the truth?
Yes.
Go ahead, Ameren.
Mr. Hickman, by whom are you employed and what is your title?
I am employed by Ameren, Missouri as a regulatory rate consultant.
And you are the same Thomas Hickman who filed rebuttal, direct, and surrebuttal testimonies in this case, which have been marked as exhibits 35, 36, and 37. Is that correct?
Yes.
And those would appear on page 5 at the top of page 5 on our exhibit list. Do you have any corrections or revisions to make to your testimonies today?
No, I do not.
So if I asked you the questions in your testimonies today, would your answers be the same?
Yes.
I move for exhibits 35, 36, and 37 into the record, please.
Any objections to admitting exhibits 35, 36, and 37 onto the hearing record?
I think so, Judge. I would request permission to vote out of the witness.
As to what?
As to his familiarity with the study upon which his study is supposedly based.
Go ahead.
Thank you. Mr. Hickman, to your knowledge, who is Vandis?
To my knowledge, Vandis is Mike Vandis, an individual that was previously employed by the company.
Okay. When was he last employed by Ameren, Missouri?
I don't know his exact dates of employment.
Did he, do you know if he left prior to 2017?
I do not know that, no.
When did you start your present position?
I'm sorry, I'm a little... In April of 2017.
April of 2017, okay. And was Mr. Vandis working there at the time?
Yes, he was.
He was there in 2017?
Yes.
Okay, so you do know that he did not leave before 2017 then?
Based on now recalling my time of moving into the department and conversations I had with him, yes.
Well, but you told me just a moment ago you didn't know if he was there before 2007, or if he left before 2017. Now you're saying he was there and you spoke to him in 2017.
Based upon now my recollection of my time moving into the group and conversations that I had with him as a member of the group, then yes, I'm asserting that I know at least at the time that I moved into the group that he was still with the company.
Okay, but you don't know when he left?
That's correct.
Okay. Why not? I mean, if you worked directly with him, you'd have no idea when he left.
Mr. Vandis was an engineer that worked in an entirely different department. It wasn't somebody that worked within the regulatory function. So I don't know when anybody in any other departments leave or join the company.
Okay. Is he available to testify here today if the commission was to call on him?
I'm not a lawyer. I don't know how this process works, but I know that he's no longer employed by the company.
Did he directly assist you in preparing your testimony in this case?
He did not know.
Okay. Did he directly assist you in conducting the class cost of service study that you sponsor in this case?
He did not know.
Okay. Did he directly assist you in preparing any of the work papers you rely on in this case?
He didn't assist me in preparing work papers for this case, but he
Okay.
did compile a study.
We'll get to that.
Okay.
He had nothing to do with assisting you in preparing your work papers.
In this case, no.
Now, in your testimony, you only mentioned the Vandus study once on page 11 in your discussion of the polls account, 364. But you relied on that classification for other distribution accounts, correct?
Yes, I did.
Okay. Now, you admit, well, do you admit that in preparing your testimony, your class cost of service study and your work papers, you did not have access to the records that Mr. Vandus relied upon for performing his work in 2009?
I had access to the results of his study, but not the underlying data, no.
Okay, you had the study from 2009, and that was pretty much it. Is that correct?
In certain supporting tabs that were within the study, but as far as, access to databases as they exist in 2009, no, I did not have access to 2009 databases.
And did you have access to the entire 2009 study?
I would say that I had access to the entire results of said study, yes.
But, but not the underlying data for the study?
I don't think I understand the question. I mean,
Well, the study was based on data, was it not?
yes, the study was based on data.
Did you have access to that data?
I had access to the information that was in the study that led to the results of the study. I didn't have access to all data as it existed in 2009, no.
Okay. What was the account balance of account 364? Now, 364 is polls, correct?
That's correct.
Okay. What was the account balance of account 364 in 2009?
I don't have access to that information offhand.
What's the account balance of account 364 for Ameren, Missouri's updated test year in this case?
I also don't think I have access to that information offhand.
You don't have access to it offhand. What does that mean?
It means I don't have the number in front of me now.
Okay. Did you look at it in preparing your study?
The number that represented the balance of polls? Yeah, absolutely, I looked at that number in preparation of my study.
But you don't have it with you.
No, I do not have the precise number that represented the balance of polls, no.
What do you have with you?
I have my written testimony in front of me.
And your study's not part of your testimony?
The study's an Excel document with a lot of complex formulas. I don't have that in front of me now.
So your study is not an attachment to your testimony?
I understand my study to be a work paper. Include it with my testimony. I don't believe it was submitted as an attachment.
Is that Paul's? Is this from his work paper? Mr. Hickman, if I were to represent you that, according to your work paper, the polls account underlying your study, that would be in the test year, updated test year. Oh, excuse me, not updated. It's a what? Oh, in your direct, okay, I'm sorry, in your direct filing. Was, let's see, this is in millions, right? Thousands, yeah, 1.39 billion. Does that sound about right?
I don't have the number in front of me, but
Take it. Do you know what the account balance of account 365 was in 2009?
no, I do not.
You know what the account balance of account 365 for Ameren, Missouri's updated test year was?
Again, I don't have that in front of me now.
Would the answer to those be the same if I were to ask you those questions about account 366 and account 367?
Yes.
Okay. Judge, I do object to Mr. Hickman's testimony being admitted. His class cost of service study, which apparently is not even part of the record based on what he testified to, unreasonably relies on the work product of an individual who is not available for cross-examination, which is unreasonably outdated. It is not relevant to the Commission's review of the updated test year plant balances in this case. And it's not appropriate.
Say that last part again, is not updated account balances, please.
It's not relevant to the review of it's not relevant to the Commission's review of Ameren, Missouri's updated test year plant balances for this case. It is not appropriate to admit his pre-filed testimony to the extent that it relies on this information, specifically his CCOS study results and his discussion of the treatment of distribution accounts in his CCOS study. Now, I would state that I recognize that experts are allowed to rely on certain other information, but the information we're talking about here, Judge, is not that sort of information. These are facts that he's relying on, that he has absolutely no independent knowledge or verification of, doesn't know if it was accurate, and so therefore, even though as an expert, he's not entitled to rely on Mr. Vandis' study from 2009, the facts contained in Mr. Vandis' study from 2009, because those underlie his current study. And then that's not the type of opinion type things that experts of others that experts may rely on.
How is this different from when an expert witness critiques the study of another expert witness?
If that expert is available to testify and that expert's study is part of the evidence in the case?
Well, let's set that aside for a minute, because that's not what we have here.
Exactly. And that's how it's different.
I understand, but would there be anything that would prevent him from criticizing or critiquing a national study?
Yeah, he is representing in his testimony that these plant values that he uses are Ameren, Missouri's plant balances. That's the difference. If he was looking at a national study, he wouldn't be saying, you know, my study is based on the plant values contained in that study. Okay, he's basing his computations and study on 2009 figures.
The inputs for his study are the outputs of the other study without the underlying data, is that correct?
Yes.
Ameren, I'm going to give you a chance to respond and or rehabilitate.
Yes, to respond, the results were of the class cost of service analysis was presented as schedules attached to Mr. Hickman's direct testimony. So that would be schedules THD1 and THD2.
Say that again, please.
Yes, sir. Schedule THD1 and THD2 are the direct schedules attached to Mr. Hickman's direct testimony and provide the results of his class cost of service study. Then the work papers provide more detailed working schedules.
Okay, now you said the schedules attached. Whose schedules are those? Are those Mr. Hickman's schedules?
Yes, sir, attached to his direct testimony.
And the work papers are attached. Are those attached?
They are not attached. And it's common practice before the commission that instead those are made available to other parties so that they can review, ask data requests upon them, et cetera. So that opportunity was given to all parties to vet this. I would also note that this Vanda study is one piece of the overall class cost of service study and has consistently been relied upon by the company in every rate case, I believe since at least 2009. So it's never been asked, and I can ask Mr. Hickman how he used the Vanda study, the output or the results of that study in his then analysis. But to the point you raised, Your Honor, this is no different than an expert critiquing or utilizing other analyses, especially subject to checking those out.
But Judge, there is no checking because Mr. Vandis isn't here. For all we know, he's not even alive. The data isn't available because it's not attached to It was prepared by Mr. Vandis in 2009, and then but we don't have that underlying data. We just have the study, and then, like you said, Mr. Hickman comes along and bases his study on the results of the Vanda study or the output of the Vanda study without having the inputs available for the Vanda study. This is entirely different than typical expert witness type product.
If I may ask my witness a question, perhaps to clarify.
Go right ahead.
Mr. Hickman, before using or relying on the Vanda study results, do you review those with an engineer or engineers to confirm whether they're still reasonable to be used?
Yes, I do. I have meetings prior to every cost of service study whereby I describe the Vanda study and what it was designed to do with distribution planning engineers, distribution standards engineers, and even certain personnel that work on SEP projects, because I know that those are big, high-dollar investments that are occurring now. So I absolutely discussed the study with current engineering personnel to determine whether the result of that study is still able to be relied upon, and I think it probably warrants clarification that I'm not relying on the exact precise plant balance that occurred in 2009. relying on percentages studied in terms of how, for example, the polls that are studied, we come up with a percentage breakdown of how much of those polls should be allocated to high voltage, primary, and secondary voltages. I'm not relying on the precise balance that existed back in 2009. I'm relying on a study that indicated what a reasonable percentage breakdown of that 2009 balance was, and then verifying with engineers that that breakdown still remains appropriate given what's happening in current distribution investment. Asking them, given how this was studied in 2009, has anything changed on the distribution system that would make you feel like results arrived at in the 2009 study conducted in this way are no longer reliable? And I get resounding answers that there are no expectations that changes have occurred. That would make the reliance of such a study invalid.
Judge, may I add a couple of things here? He keeps saying the results of the study, the results of the study. Again, we have no indication of the data underlying the study. Okay, that's number one. Number two, everything he just said is hearsay. Number three, when we asked if there was any additional information regarding the Vanda study in data requests, we were told no, there's no. I believe those were attached to Ms. Lange's testimony. I don't remember whether it's direct rebuttal or surrebuttal, but we were told that no, there is no additional information regarding the Vanda study. So for him to come in now with alleged additional information is improper, to say the least.
If I may also further respond, Your Honor.
Go ahead.
So I take it that staff is trying to object to his entire testimony to not be allowed into the record. That is overly broad. If there was a sentiment that the Vanda study should not have been relied upon or something, which was never addressed via a motion to strike or anything like that, it would only be limited to the Vanda study, the distribution analysis, and not the overall study by any means.
I'm going to overrule the objection. I believe that it would be appropriate for the parties to be able to argue what weight should be given to this evidence, but I'm going to overrule the objection.
Judge, if I might, I think I'm going to object after what I've heard based on you can't use an expert as a conduit to get another expert's opinion into evidence.
Is that what's going to happen here?
No, I don't believe that's an accurate characterization at all.
That's exactly what's happening, Judge.
Just as Mr. Hickman relies on the NABRUC manual for guidance, that's an authoritative and we would suggest that the study is not an opinion, it is an analysis, and the results are presented within his testimony. So it's not just a mere opinion. All of which could have been addressed via a motion to strike and clarified before hearing, and was not.
I'm going to overrule the objection, and the parties can argue as to the appropriate weight to be given to the Vanda study.
Would that include anything based on the Vanda study as well, Jeff?
It's your argument. With that in mind, are there any further objections to Exhibits 35, 36, and 37? Exhibits 35, 36, and 37 are admitted onto the hearing record, and I've noted the objection.
Thank you. Mr. Hickman is tendered for cross-examination.
MIEC?
Yeah. Good morning, Mr. Hickman. How are you?
Good morning, good, thank you.
I have a couple of questions for you about your rebuttal testimony, and that would be your schedule, your table TH-2. I believe that's on page 5.
Okay, I'm there.
Okay, and so the title of the table, allocated percentage of net book value, and you list in the first column some studies, and I'll ask you to explain, but some different dates and different studies. It appears from 2016 through 2022, and you note concerns that you have about a trend in the staff's results. And I was wondering if you could explain that further. What is the trend that you're concerned about?
Yes. So this table shows a set of different cost of service results and specifically focuses in on the allocation of certain distribution accounts and how that net book value was allocated through kind of a time series here. And so I guess what I would highlight out of this is that the 2016 staff study, which used the zero-intercept method, had results that were very comparable to what our current study results over a course of time have kind of shown, right? I would say that the 69.17% that is represented here for residential is relatively close to the 68.91, 70.5. Those are all within a pretty small, narrow band. And then what it shows is that in 2021, staff had adjusted its approach to distribution allocation, and that dropped from being approximately plus or minus a percent or two of 70% down to 58%, and then has further dropped down to 41% in this case. And I guess my concern is that, by all accounts and by all conversations with distribution engineers that I've had, there's no reason to believe.
What was that last statement?
I said, based on discussions with engineers, that their account is that the distribution system has not.
I'm going to sustain that objection.
Okay. I guess then I would say that I have no expectation that the distribution system has changed in a meaningful way to make such a drastic change to the distribution allocators appropriate.
And Mr. Hickman, looking again at this table, you note some shifts and changes based on staff's trending position in the way that it's allocating these, the way it's creating these distribution allocations. And from what I'm seeing in the chart, there's an increasing number, increasing percentage of these costs that are being shifted to the larger customers. Is that a correct reading of this table? And why do you think that would be happening if that's the case?
Judge, I'm going to object to that calls for speculation, and Ms. Pleasure herself is apparently doing the testifying and asking Mr. Hickman if he agrees, or asking him to speculate as to why he believes something to be the case. So that's the objection. I'd also like to just ask and clarify, since we're going to be here a while today apparently, to what extent is the commission and yourself intending to allow friendly cross-examination?
I don't know that I can give you, as to the last part of that question, I don't know that I can give you an answer as to how I'm going to pre-rule on objections that are made. At least in terms of the friendly cross. I mean, there becomes a point at which it's too much, and there's a point at which it, to a degree, is informative. And so I will cross those lines as we come to them. And I'm sorry, what was the other part of your objection? Oh, that she was asking him if he agreed with something. That's cross-examination. So I'm going to overrule.
She asked him why he thought something. It called for speculation, Judge.
Oh, the speculation one. I'm going to overrule that objection too. Go ahead.
Thank you. And Mr. Hoopman, just to clarify so there's no confusion, I really am asking you to explain the trend in, especially in the larger customer classes in your chart. You have an LGS, SPS column and an LPS column, and you discuss a trend with respect to those numbers. And I'm wondering if you can explain why those numbers are increasing and what your concerns are, if any, about that.
Sure. I think the first thing, just to kind of clarify, each one of those rows kind of stands alone and sums to, 100%. It's an allocation of a bucket of costs. So I focused on residential initially, and by virtue, if the residential allocations are going up, all the other allocations are going up to some degree. But as can be seen in the table in my testimony, the numbers of LGS, SPS, and LPS kind of are, I would say LGS, SPS in particular in 2021 and in 2022, LGS, SPS, and now LPS are, offsetting the decrease experienced by residential. My concern, I think, with this is that these results are being arrived at by use of what I would characterize as an energy allocator, which is inconsistent with industry practice of how distribution plant gets allocated. It's very commonly accepted that distribution plant is based on some amount of customer and demand, and there's a lot of discussion about how much of it should be customer, how much of it should be demand. But absent in those discussions is a discussion of energy. And so my concern with these results is that they're based on the fact that energy is being used as an allocator.
Would you characterize the increase in the amount of the cost that's being allocated to the larger classes to be concerning to you?
I would, and based on the fact that I think a not, industry accepted allocation method is being used.
I have no further questions. Thank you.
MECG?
No, thank you, Your Honor.
Sierra Club, MCU, NAACP?
No questions, Your Honor.
Renew Missouri?
No, thank you, Your Honor.
Consumers Council of Missouri?
No questions, Your Honor.
Public Counsel?
No, thank you.
Staff of the Commission?
Yes, thank you, Judge. Let me get my papers in order here. That's 98. All right. Mr. Hickman, you provided Ameren, Missouri's response to staff DR 598, correct?
I don't have a list of the DR numbers that I responded to in front of me.
Okay. Yeah. You're being handed what I believe to be the your response to DR 598. Does that look familiar?
Yes, it does.
Okay.
May I ask, is there a copy for council?
No, actually, there's not. In fact, I had planned to keep that copy. I figured he had a copy. It's 598, sorry, Ms. Grubbs, I don't have an extra copy.
What is that DR? Specifically?
It's a response to DR 598.
And what's the question being asked
The
in DR
question,
598?
the question being asked in DR 598 is, okay, I'm going to read this. It's rather lengthy, Judge, so number one, please confirm that the kilowatt hours underlying Hickman surrebuttal table TH-1 for purposes of calculating dollars per kWh are approximately, that's not confidential, is it? Okay. 13,289,139,065 residential kWh. 13,502 million.
Can we shortcut this and just give me kind of a general overview?
Yeah,
Is that possible?
Well, let's see. Yeah, it's a relationship of commercial and industrial kWh and residential kWh as well.
Okay, go on with your question.
Okay.
And was there an objection there?
Well, I'm not sure if it's actually being offered as an exhibit
Okay.
or not.
It hasn't been, no. Now, would you agree, Mr. Hickman, that this DR is asking to clarify some of the assumptions and calculations related to your surrebuttal table TH1?
Yes.
Okay.
Judge, I'll point out, you indicated we were going to take a break at 11:30. I don't know if you were watching the time or not.
I did. I've been closely watching. I thought we might get one more question out because
Judge, it's more of a building thing. So I mean, if you're looking for one question, that's not going to do you much good.
okay, then it sounds like this would be an appropriate time to recess. Now, as I indicated before, the commission has an agenda at 12 o'clock, and I don't know how long that's going to run. It may be brief, it may be longer than that. And so rather than go up there for a few minutes and come back down, I'd rather just incorporate the lunch break now. So what would be a reasonable amount of time for,
Well, since
would 1:30 be excessive?
no, I think that.
Because I want to be sure we cover the ground we need to cover today.
That was what I was going to suggest, Judge, because some of the, at least of the staff people probably need to, not sit in, but phone into the agenda, so they won't be able to actually break for lunch until after the agenda meeting itself. So I was going to say 1:30 would probably be a good idea.
Mr. Kaufman?
Your Honor, could I ask for an accommodation regarding our witness, Jackie Hutchinson? I'm not sure how long, this aspect is going to go, but we were hoping to get her on and off the stand today. Would it be permissible to take her out of order if it doesn't look like we're going to get done with this issue today?
Any objections to taking Ms. Hutchinson out of order?
Yeah,
I
does
see.
anybody have cross for it?
The company does not.
Okay, well.
OBC, you guys? I don't think we do, Judge. I mean, I guess it comes down to the commission and yourself.
Well, before we excuse her, why don't we wait until after the lunch break? That'll give me time to see if there are if I have any questions or if the commission has any questions.
Thank you very much.
So why don't we hold that? I have no objection to taking that witness out of order, and it appears that nobody else does as well. So it is now 11:31. Let's break for agenda and lunch. We will return at 1:30, and we will go off the record now. record. I believe when we left off, staff was questioning Ameren's witness, Mr. Hickman. Mr. Hickman, if you come back up and take the stand, I'll remind you you're still under oath. And staff, you can continue your questioning.
Thank you, Judge.
I think one for me will be sufficient. Thank you.
I think I'm up to what, 177, Judge?
I don't know. I thought when we left, I thought you were asking about a data request that started with a 5, but I could be wrong.
Exhibit list there. Yeah, we're up to one. We used 177, so the next one would be 178. So if you want to mark that as Exhibit 178. Mr. Hickman, I've handed you what's been marked. I'm sorry.
I'm sorry, just for, what data request is this?
It's 5, it's the response to data request 598.
Thank you. Go ahead. I'm sorry I interrupted.
Mr. Hickman, I've handed you what's been marked Exhibit 178. This is a better copy of the exhibit I'd given you before we broke for lunch. You recognize that as your response to DR 598 in this case?
Yes.
Do you recognize that?
I'm sorry, yes.
Okay, thank you.
Maybe I wasn't. Sorry.
Okay. Now, in row 6 of that, that exhibit, where it says S.A. Lange Direct, page 25, you show that staff's total recommended increase across all classes is 7.32%, correct?
Yes, it's labeled as class increase needed to achieve equal rate of return, and so that the total of that would be 7.32%.
Okay. Now, if you drop down to the yellow shaded box toward the middle of the page, it says DR question 4. Your response, you show your response to DR question 4 as 8.354%, correct?
Yes.
And question 4 was asking you to find the percent difference that comes from multiplying the values you calculated for the row you labeled staff proposed CCOSS in your surrebuttal at page 5 in a table titled TH1 by the KWH values that were used to calculate the other dollars per kilowatt hour values in that table. Is that correct?
I don't have the language of the DR, but I recall it to be requesting to calculate the percentage between the response to DR question 2 and DR question 3.
Okay. Yeah. I don't have multiple copies of this DR response, or the question, but I do have one copy. Just give it to him. I apologize. You recognize that as the DR 598?
Yes.
Okay, could you read question 4 there out loud?
Please confirm that the total value from question 3 of this data request is approximately 8.38% higher than the total value from question 2 of this data request. In the alternative, please identify the difference between the total values of the results of question 3 and question 2 as a percent of the value of question 2.
Okay. Thank you, sir. Hang on one second. I'd like to mark this Exhibit 179. Did that come? So what is it? Yeah. Mr. Hickman, if you look at the top part of what's been marked Exhibit 179, do you recognize that as from your response to DR 597?
Yes.
Okay. And in your surrebuttal testimony, I think we established a moment ago that top of page 5, you have a table titled Table TH-1. Is that correct, sir?
Top of page 5?
Yeah.
Yes.
And those average figures that are shown there in the kind of the middle of this Exhibit 179, those come from that table, correct?
Which exhibit are you,
The 179, the one I just handed you.
that you just handed me?
Yeah.
And the question is,
Those were the ones where it says residential USA average, commercial USA average, industrial USA average. Those figures all come from your table TH1.
yes.
Thank you. Now, in your response to DR 597, which is Exhibit 179, you stated that SGS sales are 97.43% commercial and 2.57% industrial, as those terms were used in your table TH-1, correct?
Yes.
Okay. And you also stated in your response to DR 597 that LGS KWH are 89.92% commercial and 10.08% industrial. Is that correct?
Yes.
Okay. And for SPS, you reported 68.54% commercial and 31.46% industrial, correct?
Yes.
And finally, you stated that LPS is or was 39.08% of the load, commercial load, and 60.92% industrial load. Is that correct?
Yes.
Okay. And starting with the LPS, if I weight 39.08% of the load at the USA average commercial value from your table, which is shown down there in the middle of the page there at 11.74 cents, and weight 60.92% of the load at the USA average industrial value from your table, which is shown there on the exhibit as 7.42 cents, I get a weighted average of 9.11 cents. Is that correct, or do you need a moment to do the math?
Yeah, with rounding, that's correct.
Okay. And you, do you agree with the remaining values provided on Exhibit 179 indicating the weighted average values are correct?
Yes.
Okay. Judge, I would at this time like to offer Exhibits 178 and 179.
Are there any objections to Exhibit 178 or Exhibit 179? I hear none. Exhibit 178 and 179 are admitted onto the hearing record. And there's no numbers on these that are in any way confidential, correct? Mr. Keevil, I don't know if you heard my question. There's no numbers on this that are in any way confidential, correct?
That's my understanding. It's not confidential. Ameren can correct me if I'm wrong on that, but I don't think they are.
Okay, thank you.
Okay, now, Mr. Hickman, if you would turn back to your Sir rebuttal testimony, page 5. Do you agree with the Ameren, Missouri's position statement on class cost of service that your testimony, quote, demonstrates that if staff study were followed to set rates, Ameren, Missouri would have residential rates 23% below the national average, while industrial rates would be 14% above the national average, close quote. Now, I'm looking at page 5 of your Sir rebuttal, I believe. You state that somewhere in there. It's in the footnote, I believe.
Footnote. I see those values in the table, but I don't see it in the body of the testimony.
Okay. Yeah, you mentioned the table, that 14% figure is in the table there, and it's referencing the line you calculated labeled as, where is it now? Staff proposed, no, excuse me, I got the wrong line. That's not 14. Oh, yeah, there it is. I'm looking at the wrong column. No wonder I can't. Yeah, it's in the line you called staff CCOS versus USA average under the industrial column.
Yes.
You see it 14%. Okay. And do you want to make any changes or modifications to this table at this point?
No, I do not.
Okay. Now you agreed a moment ago when we were discussing your response to Staff DR 598, that was the Exhibit 178, I believe. You agreed that multiplying your staff proposed CCOS values by the KWH used in these calculations shows that staff is recommending a 8.354% increase. Is that what your response there to question 4 showed on Exhibit 178 in the yellow box?
I have to read the DR. Give me a moment. Okay, I think I familiarized myself with the DR. Can you ask your question again?
Okay. You agreed that multiplying the staff proposed CCOS values by the KWH used in the calculations on your response to DR 598 shows that staff is recommending an 8.354% increase. That's what your answer to DR question 4 showed, correct?
I don't know if I agree with that characterization of saying that staff recommended that level of increase.
But that's what your math results in, though, correct? Of 8.354% staff increase.
I mean, what the 8.3% is that when using the kilowatt hours that were used to develop the rates included in my surrebuttal TH1, taking those KWH against the rates presented in the table for Ameren, Missouri's rates, and then the Ameren, Missouri rates adjusted to the levels implied by staff cost of service. And when you calculate the percent difference between those two values, you get 8.354%. That's
Okay. Now, if you look up, but staff is not recommending an 8.354% increase, correct? Never was.
that's correct.
Because in fact, if you look up stay on Exhibit 178, you calculated higher up on that page that staff's CCOS studied a 7.32% increase. Is that correct? On line 6?
I think what this is confusing is that the amount of kilowatt hours are not the same between those two calculations. The kilowatt hours that were used to calculate the Ameren, Missouri electric rates by class that were then redirected to be applied against the rates adjusted to levels implied by staff's class cost of service produce those values. So that's not indicating that staff recommended an 8.35% increase. It's simply doing the math on when you take the kilowatt hours that underlied the EEI calculation, the calculation for EEI purposes of what Ameren, Missouri's electric rates were, and you use those same kilowatt hours against the rates that represent Ameren, Missouri rates adjusted to the levels implied by staff class cost of service, that you get that amount. That's not implying that staff recommended that level of increase.
And so it's just kind of a pointless figure then?
No, it's absolutely not a pointless figure.
Well, staff's not recommending it, and you've said implied several times. So your table TH-1 then is showing that staff's recommending a 8.354% increase then. Is that correct?
No, that is not correct.
Now, before you did this, you were a Sarbanes-Oxley compliance person, correct?
In my prior
Position at Ameren, Missouri.
I was an auditor at Ameren, yes.
Okay. So you've been doing this since 2017 in your current position?
That's correct.
And in your prior position, you didn't do class cost of service studies or?
That's correct.
Okay. Is it your understanding that Ameren requested a higher rate increase than staff recommended in staff's direct filing? Or did staff recommend a higher increase than Ameren requested?
I don't recall offhand, no.
Okay. In your study, in your CCOS study, well, let me rephrase that. You did your study on Ameren's request. Staff did its study on its recommendation. Is that correct?
Yes.
But based on your total retail column of your calculated staff proposed CCOSS row, you believe staff study found that the total retail dollars per kilowatt hour in its direct case is 10.17 cents?
No, I think that's a mischaracterization of what I'm showing in this table.
But that is what shows there in the table, is it not, sir?
Those values, but the characterization of what those numbers represent is not accurate.
So what is the 10.17 cents?
I think it would be easier if I just tried to step through this table and what it represents.
Yeah, that is really not what I asked you, Mr. Hickman. What's the 10.17 represent out there on line 4? Says that Ameren, Missouri rates adjusted to levels implied by staff CCOS, total retail 10.17.
I think consistent with the footnote, it says that these values were created by applying staff's proposed revenue requirement allocations by class to residential, commercial, and industrial categories in proportions informed by company load research.
Who did that math?
I did that math.
Now, looking at your Ameren, Missouri row in that same column of the exhibit, you found the Ameren, Missouri study was based on a total retail dollars per kilowatt hour of 9.48 cents. Is that correct?
I'm sorry, can you repeat that?
Yeah, looking at your Ameren, Missouri row. Yeah. In that same column, you found the Ameren, Missouri study was based on a total retail dollars per kilowatt hour of 9.48 cents. Is that correct?
Again, I think that's a mischaracterization. This table is an extension of something that was filed in my rebuttal testimony. These figures are EEI average rate numbers. That's what the U.S. average is, and the Ameren, Missouri one are the Ameren, Missouri average rates as reported to EEI over a period of time. Those rates don't have a direct correlation to my study.
Now, looking at the rows just below the one we were just talking about, you found the total retail percent change. And there it shows that your calculated staff proposed CCOSS row is 13% less than the U.S. average. But that Ameren is 19% less than the U.S. average. Now, are you confident that staff recommended Ameren get a 7% bigger increase than it requested, or could you have made an error in that calculation of staff's proposed CCOS row?
Once again, I think that's assuming that the Ameren, Missouri row relates to our cost of service or our filing or anything. It does not. That's a baseline. That's what our rates were for a period of time as measured and reported to EEI. What the staff proposed class cost of service row does is applies increases, and it makes no assumption of change in billing units or underlying kilowatt hours, and says, okay, well, if the rates are going to go up by the percentages as proposed in staff's testimony, then what will those rates become? So it's a measure of rates prior to increase against the rates with increase, and it's not a matter of the overall change, it's the magnitude and difference to the U.S. average and the directional changes that are being made. So
that's good enough. So you're comparing apples to oranges and maybe a few mangoes thrown in there.
I disagree with that, no.
Yeah, of course you do. You're paid to.
Objection, strike the last comments and not questions from counsel for staff.
That'll be sustained.
This one, or no, we need this other one? No, I guess this is it. Yeah. Okay. Yeah, why don't you hand that out? Keep one. All right, Mr. Hickman, you've been handed a new exhibit. It should have been marked Exhibit 180. I apologize, I didn't mark that before we handed that to you. Now, do you, on the top of that, you see your required class revenue by class to equalize rates of return from your direct Schedule 2? And you should find your kilowatt hours by studied class from your direct work papers. You see those two things?
I see the Ameren study results in my schedule, in my direct, and what was the other question?
Your kilowatt hours by studied class from your direct work papers?
I don't have my work paper to verify those numbers.
Do they look right?
I can't confirm that without my work paper.
Do you have your work papers here in the room?
I do not.
You didn't bring your work papers with you
No,
on the day you were scheduled to testify?
that's correct.
Does your counsel have your work papers?
I'm not sure.
Okay.
I believe we might be able to have an electronic copy available. They are spreadsheets, dynamic, so printing them can be difficult, but we, I believe, could provide him a laptop that would have the work paper open,
Okay.
if that is
I'm going to back up for a second. What is this?
That's Exhibit 180.
I understand that. What is it?
It's a comparison of the kilowatt hours and the, the studied kilowatt hours and the study results in dollars and kilowatt hours. And we will,
Is it a response to a DR? Is it demonstrative?
well, it's partly, like I said, it's partly from his direct testimony. The first column, Ameren study results, that's his, well, you can see down there at the bottom with the asterisk. Part of it's from his direct schedule, part of it's from his work papers, and part of it's from Ms. Lange's direct testimony.
I guess I'm asking who created it.
Putting this together, we did,
Okay, thank you.
but those are the sources down there in the footnotes.
Your Honor, may I approach the witness with the
Yes, please, go ahead.
laptop? I'm just going to explain to him that each set of work papers for direct rebuttal and rebuttal are in different file folders. These are direct, and if you go back to the root, you got to go to our company rebuttal testimonies, or rebuttal to find the directory for work papers. Okay. Mouse in case you need it.
There's a question hanging in the air. I'm unaware of it.
Yeah, the question was, hang on just a second. On the Exhibit 180, does Mr. Hickman recognize his kilowatt hours by studied class from his direct work papers? Or in the column headed Ameren study kilowatt hours.
Yes, I can confirm those are the numbers from the referenced tab of my work paper.
Thanks.
And location.
Now, the next column over, the Ameren dollars per Ameren kilowatt hours column, you see that?
Mhm.
Now, can you verify that the figures in that column are properly calculated, or do you accept that those values depict your CCOS study results?
I assume it's okay if I use this calculator. That's,
Sure.
Okay. Okay.
once I get
Yep.
to it. You confirm those, sir?
Yes.
Okay, thank you.
Hmm?
I'm gonna skip it over to here once I get to over here. Okay, now, moving down to the next area on the Exhibit 180, we see the values that we just calculated, or you just calculated, labeled Ameren dollars per kilowatt hour. And we see a column for staff's direct study results divided by staff's kilowatt hours. And we see a column reproducing those values of the USA commercial and industrial averages weighted to Ameren, Missouri's class composition. Now, do you agree with the way I've described those numbers, sir? Or do you need to verify any of them?
What was your character, I'm sorry, what was the characterization of the staff study numbers? I agree with the other two, I'm just
Okay,
trying to keep up.
it's the staff's direct study results divided by staff's kilowatt hours from Lange's direct testimony.
Yeah, I don't have that in front of me, but if that's what they are, that's,
Okay. Now, in your surrebuttal testimony, going back to that table TH1, where did old TH1 go? There we go, TH1, yeah, I found it finally. You calculated that staff CCOS results in an industrial rate of 8.43 cents per kWh. Is that correct?
yes.
Okay. Now, looking at this chart, or if you prefer, you can look at Lange's direct, page 2. Can you tell me, is that LPS study value of 7.34 cents higher or lower than the 8.43 cents you allege staff found in table TH1?
The value of 7.43 or 7.34 is less than the value of 8.43.
Okay. Is the SPS value there on Exhibit 180, the of 8.21 cents higher or lower than the average value that you claim?
Well, the average value I claim is over industrial, which isn't directly comparable to primary service customers of an individual class. That's why we did our weighting exercise to make them comparable. So again, and that's why my characterization was 7.34 is less than 8.43. I agree that 8.21 is less than 8.43, but I don't agree with the characterization that that's the same, representing the same value.
Well, the classes themselves, there is no industrial class for Ameren, is that correct? Ameren, Missouri, sorry. Rate class.
There is no industrial rate class. Industrial is a category of summary that's used in other relevant manners.
Thank you. And there's also no commercial rate class that for Ameren, Missouri, is that correct?
Right, again, that's just a category of costs that are summarized that doesn't relate exactly to the weight classes, or to the rate classes, excuse me.
Okay. Now, both the company and staff separately allocated EDI discounts so that the classes with EDI customers would not be effectively penalized for those discounts in the CCOS, correct?
I'm not sure I understand the question. Can you repeat it?
Yeah, but when I say EDI, I'm referring to economic development incentives, just for the record. That both company and staff separately allocated EDI discounts so that the classes with EDI customers wouldn't be effectively penalized for those discounts in a CCOS. Is that correct?
I don't allocate discounts in the class cost of service. If I'm understanding what you're asking, the treatment of EDI would have been in the way that we calculated revenue. So yeah, I'm not sure I understand the question.
Let me switch slightly here, Mr. Hickman. Under Ameren's EDI, qualifying customers receive an average 40% discount on their electric bill for a set term. Would you agree with that?
As a general characterization, sure.
Okay. Would you agree that on April 4th of this year, Ameren filed what it called the 21st EDI agreement under Ameren, Missouri's rider EDI?
I don't know the date or about that filing. No.
Okay. Do you know how many EDI discount, or how many EDI contract, I apologize, how many EDI customers, there we go, Ameren, Missouri currently has?
I do not know that, no.
Okay. Hypothetically, just to assume it's 21, okay? Would those EDI discounts be showing up to reduce the average dollar per kilowatt hours for staff or for Ameren when we're comparing to the U.S. average?
I don't know. I still don't think I understand.
Let me reword it and see if it makes any more sense, Mr. Hickman. Those EDI discounts that Ameren is giving certain customers are in fact not showing up to reduce the average dollars per kilowatt hour for Ameren when compared to the U.S. average, are they?
What comparison are you specifically referring to? Because I think I've got a handful of comparisons.
Well, like
now
if you look at Exhibit 180, those national averages compared to Ameren's study results and staff study results, Ameren's and staff study results do not reflect the EDI discounts. Is that correct?
That is correct.
Would you agree also that residential customers are not receiving EDI discounts.
Yes, that's correct.
Judge, I don't think I offered Exhibit 180. I would go ahead and offer 180 at this time.
Any objections to Exhibit 180? I hear and see none. Exhibit 180 will be admitted onto the hearing record. I'm going to ask you, Mr. Keevil, is this going somewhere?
When you say, is this going somewhere, are you referring to the exhibit or?
This line of questioning.
Oh, the line of questioning just ended.
Okay.
That's why I wanted to get Exhibit 180 in.
Those are all your questions for this
Yeah,
witness?
I'm through with them, yes.
Okay. Thank you. Any redirect?
Yes, Your Honor, thank you. Mr. Hickman, if you would please turn to your sir rebuttal testimony, table TH1 that you were questioned by staff counsel on, please.
Yep.
You mentioned that you would not make any changes to that table based on the calculations presented in Exhibit 180. Is that accurate?
Yes, that's accurate.
And so, can you walk through table TH1 and what it is presenting or comparing?
Sure. So table TH1 has 5 rows. The first 2 rows are the presentation of average rate data as reported to and from EEI. The Ameren, Missouri number, we report to EEI, then EEI re-reports that out as a part of their report. The U.S. average is also how the EEI presents numbers. So the first row is just a simple calculation of average realization rates by residential, commercial, and industrial buckets. So you total up the residential revenue, the residential kilowatt hours for the given period of measurement, which is, a rolling, 1 year at a time, and calculate what the average rates is. And it's meant to provide a comparative tool for utilities to see how their rates compare against other jurisdictions, other states, the U.S. average as an example. The third line is just a percentage difference calculated between the values in 1 and 2 to show that, for example, in residential, Ameren, Missouri's number of 11.1 is 23% lower than the U.S. average of 14.39. The fifth and sixth row, starting I guess with the fifth is a calculation where we took staff's direct filed position of how their rate increase breaks out. I'm going to reference back to the exhibit. So the class increases needed to achieve equal rates of return. And then we had to do weighting because, as was pointed out, residential, commercial, and industrial are not our rate classes, but we do have numbers that tell us how many of our kilowatt hours are kind of broken down in those capacities. So we used weighting factors to take what staff's direct proposal increases were and basically say, if you take the Ameren, Missouri rates as reported and don't assume any change in kilowatt hours and assume that they change, if the rates changed equally across, the different rate elements consistent with staff's increased proposal, what do those rates look like? So then the final line are the percentage increases or changes that show, okay, just using Ameren, Missouri as a baseline, if we follow staff's proposals, how do the percentages change compared to the U.S. average? And I think a key thing here is the directionality of the change as much as it is the magnitude. Obviously, following our proposal, our rates would be higher, and that's why I think the 19 to 13% comparison was kind of missing something. I wasn't trying to assert that those two are showing a difference or a relative magnitude of the increase. It's just showing if we follow Ameren or staff's proposal and our rates change by those values, how do we stack up against the U.S. average is kind of a benchmark.
And Mr. Hickman, you were asked questions earlier by staff counsel about the Vanda study. Do you recall that?
Yes.
And can you describe how you use the Vanda study?
Sure. So the Vanda study is a study of our distribution system, or was a study of our distribution system, designed to help inform how classifications of distribution investment should be allocated between high voltage, primary, and secondary voltage. And the importance of that is if you have assets that are only providing value at the secondary level, for example, that you wouldn't want to allocate those costs to customers that are receiving service at a primary voltage level. It doesn't really make sense. Why would they be paying for secondary service or secondary equipment when they're served at primary? They're kind of agnostic to the existence of the primary system. So the Vanda study is a review of our distribution assets to help identify that. And for example, for poles, it's a review of our poles to look at a pole and say what types of equipment are attached to that pole. Is it primary, high voltage, or secondary? And then uses, that survey or that sample to make an assessment of how does the entirety of that account kind of break down. Again, either on a sample basis or if we have information that's more inclusive of what's in the entire account. So the results of those are percentages based on a review of the snapshot of our system at any point in time. The absolute value of the system at any point in time is kind of, irrelevant to that unless there's any expectation that the ratios related to that have changed over time.
To your knowledge, has staff ever relied on Ameren, Missouri's Vanda study in distribution classification?
Yes, they have, in the 2019 rate case.
I have a document to distribute. I would represent that it's an excerpt from the Ameren 2019 electric rate case. It's staff's class cost of service report, and it's just an excerpt, and I can identify the pages. But I wanted to save trees and not print off the full thing. So, Your Honor, this, as the cover sheet indicates, is from case number ER-2022-0337, which relates to Ameren, Missouri's electric rate case. And the excerpt that was distributed has the cover sheet, the table of contents, and then an excerpt of pages 8 to 25. Since it is already in the record in that docket and available on EFIS, I don't know if you want to take just notice of it or if you would like to mark this as an exhibit.
what's the purpose of this exhibit?
I asked Mr. Hickman previously if staff has relied on the class cost of service study, and there are references within this just to confirm that they relied upon the Vanda study in the 2019.
Okay, and I believe your witness said yes, they did, and I believe you could probably ask that of a staff witness too. I don't really understand what the importance is in getting a previous class cost of study in if that's all you're trying to demonstrate.
There was a question or challenge presented that about what weight should be given to the class cost of service study, or more specifically, the Vanda study. And so it was just, again, going to weight to be given that staff has even relied on it just 2 cases ago.
Okay, I'll take notice of the class cost of service study in ER-2022-0337 for that purpose only.
And you take notice of the entire report, not just a select few pages, correct?
That is correct,
Thank you.
but I am limiting it to this purpose.
Well, okay, well, let me just say, Judge, that I think when
If you want me to expand that, you're welcome to ask.
No, I'm just, when you look at this, I think it's important to recognize that 2 cases ago was a rate decrease, I believe, rather than a rate increase. So, something to keep in mind when reading anything from that case.
Okay, with that in mind, I'm not going to mark it as an exhibit, but I'll take notice of it for that purpose. Go on.
So I was then going to go to a specific page within that. Would you please turn to page 14? Looking at lines 10 and 11. So this, is this consistent with your recollection that staff relied on the Vanda study presented by Ameren, Missouri in its work papers for classifying the remainder of account 364?
Yes.
And then on the next page, page 15, at lines 4 through 6, is this consistent with your recollection then that staff relied on the Vanda study as presented in Ameren, Missouri's work papers to classify the remainder of account 365?
Yes, it is.
And was the Vandis study prepared by one person, Mr. Vandis?
No, it was not. It was performed by a group of engineers and in conjunction with individuals working on cost of service at the time.
Does the age impact your use of the Vandis study?
No, it does not. The Vanda study, as I described it, is informative to percentage allocations of certain types of assets between voltage. And I think, as I kind of indicated in my earlier description of how it's used, unless there's some reason to think that we're using distribution assets in a different way now than we were back in 2009, at the time that the study was performed, and I have no belief that we have, and I've confirmed with our distribution engineers that that's not the case.
He's explaining, if I may respond to the objection.
Yes.
He's explaining that he confirmed it was his actions. It wasn't an out-of-court statement or out-of-commission hearing room statement being used. It's not hearsay.
It is if he says he confirmed with the engineers. I mean, that's not something. I'm going to sustain the objection as to that.
Was there anything further that you?
No, I confirmed my belief that that there was no expectation.
with the engineers, and then went with the same answers. It's the same thing he was saying a moment ago. This whole line of questioning is pointless because she's already got the notice of the report for, the fact house service report from the 2019 case taken notice of, so, I have to object to that.
We're going to wrap this up pretty quick, but I'm going to let him answer as to what his belief was.
My belief,
So that'll be overruled.
my belief that the distribution system has not had any significant changes that would invalidate a study conducted in 2009.
Thank you, Your Honor. That's all of my questions.
Mr. Keevil, when you're making an objection, if you could speak into the microphone, I'd appreciate it. I don't think everybody's picking it up.
Okay, I apologize, Judge.
We got a little out of order. Because of that, I think redirect came at the wrong time. But what I'm going to do right now is I'm going to ask, are there any commission questions?
No questions, Judge. Thank you.
No
Thank-
questions, Judge. Thank you.
Thank you, commissioners. I have some questions for you, Mr. Hickman. Do you know if Ameren has used a class cost of service method other than the 4 NCP in a Missouri rate case in the last decade?
I don't believe so.
Is that within your realm of knowledge?
My involvement has been since 2017, but I have reviewed prior cost of service models. Past decade would take us back to 2013. I can confirm at least back through the 2016 case. I know that I've looked and it hasn't. I can't remember if there was another case since, I want to say the prior one was 2012.
Does the 4 NCP methodology include any considerations for renewable generation plant characteristics that are different from baseload generation?
No, I would say that it doesn't.
Does the 4 NCP methodology include any consideration or use of AMI data that can differentiate between rate class energy consumption during the hours of the day?
No.
Now, that 4 NCP method, I forget which witness, and it may have been you, that comes from the 1992 NARUC manual, is that correct?
Yes, that's correct.
If that manual were to be updated, do you think it would be appropriate to differentiate between costs of dispatchable and non-dispatchable generation?
I don't think so, and I think just in a very simple way, I would say that the 4 NCP average and excess approaches production allocations more from the perspective of understanding what our customers' energy and capacity needs are more holistically, and says that, okay, we've built a production system that meets these energy and capacity needs, and that's the basis of allocation. It doesn't differentiate or treat differently which of those assets are contributing to which. It's more about just, our customers need this much energy and capacity. This is the way in which we've addressed that with a system, and that's the manner in which we're going to allocate it to our customers.
I've heard the term rate modernization thrown around a few times. What does that mean?
I think that would probably be a better question for Steve Wills. I work on cost of service, but when it gets into the specific rate design components, you know, I have some input and say, but rate modernization is a pretty broad term that has to do with a little bit more than just the cost of service aspect.
If the 1992 NARUC manual were to be updated, do you think allocation of costs based on customer AMI data should be considered?
Can you repeat that once? I'm sorry.
If the 1992 NARUC manual were to be updated, do you think cost allocation should be based on actual information from customer AMI data? Do you think that should be considered in any update of the NARUC manual?
Yeah, I don't know that the NARUC manual specifically says that it should or should not. I think that's, you know, I don't think an update to the NARUC manual is necessary to acknowledge the benefits of information gained through AMI meters in some capacities. Some of that relates to just, you know, one of the major inputs to cost of service is load research, where we kind of have sample meters and we infer what those sample meters tell us about how energy is being used more holistically. If we end up with data out of all of our AMI meters, there's the potential that we can make that update, and that's not something that's specifically driven by what's written in the NARUC manual. So I'm sorry if that's not the best answer, but I think that, you know, incorporation of AMI data can happen, you know, agnostic to any kind of update out of the NARUC manual. I don't know that what's prescribed in the NARUC manual would specifically change as a result of the AMI data.
Now, when you say agnostic there, I'm not really following you. So what do you mean when you say it's agnostic to, if you say AMI data is agnostic to the NARUC manual's 4NCP methodology, what do you mean there?
Well, so in the 4NCP method, we use energy and demands as certain portions of that calculation. And again, that energy total and that demand total are derived out of our load research process. So the existence of AMI can improve that as an input, but it doesn't mean you would necessarily do something different with 4NCP average and excess. You would just have a better, more complete population of data to inform the application of it, if that makes sense.
Do you ever see a point in the future where the 4NCP method would become obsolete?
I'm not aware of anything that would drive the method to be obsolete, no.
So you think this could be used out into the future somewhat indefinitely?
I wouldn't want to guarantee certainty that nothing changes, but I am not aware of anything that would make me think otherwise.
You may need to get additional papers for this, but do you have Ms. Lang's rebuttal testimony in front of you?
I do not.
Does anybody have that to give him?
I may, it's on the computer.
Please.
I'm sorry, you said rebuttal?
Rebuttal. In particular, page 21.
Do you have a line number?
Paragraph 8.
Okay.
On page 21 of Ms. Lang's surrebuttal testimony, she cites a stipulation and agreement in case number ET-2018-0132 in paragraph 8, that Ameren agreed to record customer contribution values by voltage and service classification. Is that correct?
Yes.
Has Ameren, Missouri complied with paragraph 8 of the stipulation and agreement?
I believe that we have, it's been a long time since I've specifically looked at this language and reference back to the meetings that we had relating to it.
Where would I find the results that show that Ameren complied with that stipulation and agreement term?
I think, as I said here, I'd have to look into it further. I don't recall whether, we, at any point in time, we had pulled together information to support compliance with this or not.
Okay, so just, you think that Ameren has complied with it, but you don't know, correct?
Correct.
And you don't know where I'd find the results that indicate that Ameren has complied with it, correct?
I guess I don't know of anything, like in the case or on the record that addresses this. I don't know.
Can you go to page 29 of Ms. Lang's surrebuttal?
Sure.
On lines 3 to 11, she states that 70% of Ameren's smart energy plan and plan distribution spending will be allocated to small customers. Do you agree with that analysis?
Yes.
Why? Or can you explain that to me?
Sure. And this, I guess I would say admittedly, this is an area that the company is considering changes to for future rate cases, as we've had some conversations. The reason for this is that our current cost of service model considers devices to be customer related in their allocation. And I would say what our current thinking is, and we need to do some further kind of analysis to see how this would support. But I believe a different position that devices should be allocated kind of consistent with the underlying investment in the conductor that's in the same account would be more appropriate. Devices, there's a lot of different devices, but devices broadly could be switches and reclosers and lightning arresters, things like that. And I think there's a criticism that no portion of the devices should be considered customer related, and I think I continue to maybe disagree with that because I think those devices, in my mind, are kind of an extension of that underlying investment in conductor. But to answer your question, the reason that 70% of it's being allocated to small customers, and small customers is kind of ambiguous, but I think it just relates to our smaller rate classes, is because we have historically viewed those devices as being driven by the number of customers that we have, not the amount of demand that's on the system.
Say that again, please.
We have historically viewed those devices to be driven by the number of customers that we have on our system, not the amount of demand that those customers drive on the system. That's what's really at issue here, is that any of our distribution investment gets broken down into a customer-related bucket or a demand-related bucket, and then whatever's customer-related gets allocated based on the number of customers that you have. Well, our smaller customer classes have larger amounts of customers and less demand per customer than some of our larger classes. So that's the mechanical reason why this is occurring, is that we, in our current approach, identify devices as being driven by customers, and that the smaller customer classes have more customers relative to the amount of demand per customer. But I guess, again, I would kind of say that that's something that we're reviewing and considering modifications to in future cost of service studies.
And what modifications are you looking at?
Specifically, again, I think viewing devices more as being driven by how the underlying investment in conductor is split between voltages is probably a reasonable potential improvement. So said another way, if we study the conductor and determine that the conductor is split, half customer, half demand, and we end up with studies that support that, then the devices should also maybe be split 50-50 instead of all being related to just the number of customers, and that would drive that number down mechanically.
So currently, those are allotted to customers, or assigned?
They're assigned on the basis of the number of customers. I think there's still certain devices in there that, the reason I'm not maybe as super positive is that I think we want to look at exactly what's in those devices. I'm not sure that something like a lightning arrestor has a large relationship to the amount of demand on the system. They're just placed to protect equipment, and the existence of equipment is generally more viewed as a customer-driven cost, whereas the sizing of the equipment is more driven by demand. So, but in general, I think that we're interested in looking at modifications in that area.
Now, in the last Ameren general rate case, file number ER-2021-0240, which party's class cost of service study was agreed to as a starting point for the non-residential rate design working case?
I'm not sure that the last case informed what should be used for the starting point of the non-residential rate design workshop. I recall earlier, and I think even in opening statements, somebody had quoted some information from the report and order that talked about the reasonableness of a study, but that it wasn't used specifically in the revenue allocations in that case. But I don't recall that tying in with a starting point for the rate design docket.
Do you know where in the stipulation and agreement or in the commission's decision I would find that information?
The information on,
Which party's cost of service was a starting point?
for the rate design,
Yes.
again, I'm not sure that that exists. I think the statement in the order was on the reasonableness of the Ameren, Missouri study, that was not used for revenue allocations, but I don't believe that section, had anything to do with or said anything. And that section nor any other section that I can think of directed what would be a starting point for the rate design docket.
Did you participate in the rate design docket?
The rate, if I'm understanding what we're asking about, the rate design docket I don't think has been ordered
I'm
yet.
sorry. Were you a part of that rate case?
I was a part of the rate case, yes.
Was there an understanding as to whose class cost of service study was going to be starting point?
I think if you're,
I know I'm asking this a bunch of different ways.
no, I understand. I think if you're asking about maybe understandings, I would direct you maybe to ask Steve Wills. I wasn't involved in the actual settlement process. I was a cost of service witness in that case. I've read through the order. I was engaged in the case. But I wouldn't hold much insight to any understandings or anything that existed as a part of that process.
If there were a class cost of service study that the parties had agreed to in the last rate case as a starting point, should that be the starting point? Should that be a starting point in this case?
I don't know if I really have a strong or definite perspective on that.
Those are all the questions I have. Any recross based upon bench questions? Any redirect?
Not necessarily. I guess I want to clarify on the ET stipulation that you referenced. Do you perhaps want to take judicial notice of that docket? And to my knowledge, no motions to compel or anything like that have been submitted in it, suggesting that there was not compliance with the stipulation? Or we could separately reserve an exhibit number to submit information.
Judge, I'm a bit lost here. I don't even know what she's talking about at this point, but my recollection is that the failure to comply was with whether or not they had conducted this study, but in 2021. Yeah, it was a but my recollection is it was a contested issue in the 2021 rate case. So it would be something coming out of that, what was that, the 240, the 0240? Yeah, the 2021 0240 case, whether or not they complied with the order there.
So I guess I could either expand or ask if you want to take judicial notice of the electric rate case ER-2022-0337.
Why, though?
I was just trying to provide a way for the judge to have additional information to respond to that, or you could also ask Steve Wills, company witness as well.
Well, yeah, we can answer a lot of Ms. Lange can answer a lot of questions about that. I mean, there's no reason to take official notice of an entire different rate case docket. Good Lord.
If you can hold on a second, that would be what I would prefer too. If I can ask those questions of Mr. Wills and Ms. Lange, I'd prefer to go ahead and do that rather than just dump a whole bunch of unnecessary paper into the record.
Thank you.
Is that all?
Yes.
Okay. Mr. Hickman, you may step down. We are now at 3:04. This seems like a good time to take about a 15-minute break.
Your Honor?
Yes.
Yes, could I, with regard to the testimony of Jackie Hutchison, do we know if there's any questions of her today, or?
I haven't received any at this point.
Okay,
So-
could we take care of her testimony, or offer that into the record then, or
Is there any objections to doing that at this point?
you want, Nathan, okay, you don't have anything?
That's what she has, Joe.
Okay.
Direct rebuttal, sir?
Yeah, yes, we have,
Rebuttal, sir, rebuttal?
there is there's direct and rebuttal
Direct rebuttal, okay.
for Jacqueline A. Hutchison, and those are labeled as Exhibit 300 and 301. The direct testimony of Jackie Hutchison and the rebuttal testimony of Jackie Hutchison.
Are either of those confidential?
No.
And I don't have an exhibit list for you, is that correct?
That's true. I can file one if you'd like.
No, that's not necessary. I just want to be
Those two
sure that I'm
exhibits
putting
are
it.
all we-
Any objections to admitting Exhibit 300 and Exhibit 301, the direct and rebuttal testimony of Jacqueline Hutchinson? Onto the hearing record. I hear and see none. Exhibit 300 and Exhibit 301 will be admitted onto the hearing record. Yes.
Oh, thank you very much.
Judge, just in the interest of full disclosure here, before we break for 15 minutes, over the lunch break, I emailed you staff's exhibit list, which the other parties, or the parties received yesterday. So it was had already been sent to the parties. We just forgot to copy you. I apologize, but you should have received one over lunch.
I appreciate that. I received it. I printed it out, and I've been using it.
Judge, just so everyone knows, I broached this to you before we started the hearing after the lunch break. Jeff Mark is not going to be available today.
And we are still 2 witnesses away from him, so let's cross that bridge when we come to it. I don't think that'll be an issue. All right, It is now 3:07. Why don't we come back at 3:25? We'll be in recess, and let's go off the record. Ameren, you can call your next witness. Is that Craig Brown?
Yes, it is, Your Honor.
Mr. Brown, would you take the witness stand and please say and spell your name for the court reporter?
Craig Brown, C-R-A-I-G-B-R-O-W-N.
And would you raise your right hand to be sworn? Do you solemnly swear or affirm that the testimony you're about to give at this evidentiary hearing is the truth?
Yes, I do.
Ameren, go ahead.
Thank you, Your Honor. Mr. Brown, by whom are you employed and what is your title?
Employed by 1898 & Co., and I serve as a senior project manager.
And on whose behalf are you testifying today?
On behalf of Ameren, Missouri.
And you are the same Craig Brown who filed sir rebuttal testimony in this case on behalf of Ameren, Missouri, which has been marked as Exhibit 38.
Yes, I am.
Do you have any corrections or revisions to make to your rebuttal testimony?
I do not.
So if I asked you the questions in your testimony today, your answers would be the same?
Yes.
I move Exhibit 38 into the record, please.
Any objections to Exhibit 38? I see and hear none. Exhibit 38 will be admitted onto the hearing record.
Mr. Brown is tendered for cross-examination.
Thank you. Any cross-examination from MIEC? Any cross-examination from MECG?
No, thank you, Your Honor.
Any cross-examination from the Sierra Club, MCU, or the NAACP?
No questions, Your Honor.
Any questions from Renew Missouri?
Thank you, Judge. No questions.
Any questions from Consumers Council of Missouri?
No questions, Your Honor.
Any questions from Public Counsel?
Not at this time, thank you.
Any questions from the Commission staff?
Just very quickly, Judge, Mr. Brown, when were you first retained by Ameren, Missouri for purposes of this case?
I don't recall the exact date. I believe it was late February, early March. I don't recall exactly the date.
Of this year?
Of this year, yes.
Okay. And you work for what consulting firm?
1898 & Co. It's the consulting division of Burns & McDonnell Engineering Company.
Burns McDonnell, okay. And what sort of remunerative arrangement do you have with Ameren, Missouri for this case?
I'm sorry?
What's your deal with Ameren, Missouri? How much are you getting paid?
Oh, it's a time and materials contract. It wasn't a fixed fee or anything.
Okay, what time and materials for an hourly rate?
Hourly rate, yes.
What's the hourly rate?
Objection, irrelevant.
Staff wish to respond?
Well, yeah, Judge, it's always, the hourly rate of an outside consultant is always relevant for purposes of bias and I've never heard that objection in an expert witness hearing to asking that question for an outside consultant. But
You can answer the question.
I believe my company
Objection
receives.
will be overruled.
Okay. My company receives $389 an hour.
389, okay. That's all I have, Judge, thanks.
Mr. Brown, are there any commission questions? I hear none. Mr. Brown, should renewable generation be considered differently than baseload generation in a class cost of service study?
In the context of, well, you look at generation, which is allocated both, it's classified both as energy and demand. In the demand side of that, no, I still do not feel that it needs to be treated differently.
Why is that?
I think that when utilities build generation, it's for multiple reasons. But at the end of the day, it's all there to serve the capacity needs of the system. In some ways, renewables have been added onto the system more recently to meet certain standards. But it's still there to serve the needs of the capacity of the system. You know, if there wasn't a need for capacity, you wouldn't be building it. And so therefore, I believe that treating them as a fleet of generation resources is still reasonable.
As opposed to dividing them up?
As opposed to dividing them up, yes.
But you would agree that at least in regard to they have different dispatchability availability
They do have different dispatchability, yes.
and different costs of generation.
From a fixed and variable rate structure, yes. But in, you know, from a fixed and variable standpoint, you know, you could compare something that's upfront capital with very low variable cost. That's renewable, but that's also nuclear. You know, your investment's all upfront, that there's really no fuel costs. So it's, but that's obviously built for capacity. So it's, you know, in certain situations, it's all comes back to a blend of capacity and energy, and I don't think there's a reason to single it out separately. If there were certain costs that were very much energy related, they would be classified as energy. But from an overall standpoint, I don't think they need to be separated.
Okay, thank you. I don't have any further questions. Are there any questions or based upon commission questions or bench questions? Any redirect?
No, thank you.
Okay, Mr. Brown, you're excused. Ameren, you may call your next witness.
Thank you. The company calls Stephen Wills to the stand.
Mr. Wills, will you take a seat and say and spell your name for the record?
My name is Stephen Wills, Stevenwills.
And would you raise your right hand to be sworn? Do you solemnly swear or affirm that the testimony you're about to give in this evidentiary hearing is the truth?
I do.
Ameren?
Thank you. Mr. Wills, by whom are you employed and what is your title?
I'm employed by Ameren, Missouri as the Director of Regulatory Affairs.
And you are the same Stephen Wills who filed direct rebuttal and surrebuttal testimony in this case, which have been marked as Exhibits 39, 40, and 41?
Yes, I am.
Do you have any corrections or revisions to make to your testimonies?
No, I do not.
If I asked you the questions in your testimonies today, would your answers be the same?
Yes.
I move Exhibits 39, 40, and 41 into the record.
Any objections to Exhibit 39, 40, and 41, the direct rebuttal and surrebuttal testimony of Stephen Wills? I hear none and I see none. So Exhibits 39, 40, and 41 will be admitted onto the hearing record.
Thank you. Mr. Wills is tendered for cross-examination.
Thank you. Any cross-examination from MIEC?
No questions, thank you.
Any cross-examinations from MECG?
Briefly, Your Honor. Mr. Wills, at the time the company filed its rate case, it was asking for approximately $316 million in revenue requirement. Is that correct?
An increase in revenue requirement. Yeah.
And that would be an about 11.6% increase that the company was proposing to collect from each class.
That's correct.
And are you aware that there's been a revenue requirement stipulation filed in this case?
I am.
And the company's settled revenue requirement increase is $140 million, is that correct?
Yes, $140 million increase over present revenues.
And do you, since the company's position is still that that should be collected on an equal percent basis from the classes?
I think that is our position. I think, it certainly makes, it may be more reasonable for consideration of other things, but I think our primary position is that it would still be on an equal percentage basis.
Have you calculated what that percentage would be for each class?
I believe it is 5.1%.
Have you done any calculations to evaluate what the class percent increase would be under the recommendations of MECG's witness?
I haven't done any specific calculations.
Have you done any calculations to estimate what the percent increase would be under the recommendations of MIEC's witness?
I haven't done the calculations myself, no.
Okay. Switching to, I guess, class cost of service, your methodology, or I'll say the company's methodology, is the average and excess for NCP, correct?
For production demand-related costs.
Production
yes, it
demand.
is.
And even though you are recommending essentially the same revenue spread as the commission staff, you understand they have a very different class cost of service method, correct?
Yes, I do.
And are you aware of any other utilities that have been, have had class cost of service studies performed using the staff's method?
I'm not specifically aware of any other utilities that have had class cost of service studies using those methods.
Were you in the hearing room for opening statements?
Yes.
I think there was, the staff counsel was talking about if you decide something to the effect of if you decide equal revenue allocation, you don't need to decide which class cost of service is better. Do you recall hearing that?
I do recall that.
Would you agree that that's not necessarily the case, that there is benefit to a commission determination in this case on which class cost of service method is better?
I think there would be absolutely some benefit from that. I mean, ultimately, over the last few cases, we've seen really significant divergence from, a situation where, as recently as 2016, class cost of service results were reasonably similar across companies, across parties. And there were certainly disputes about specific allocations, and, there were still not complete agreement, but we've just seen this widening gulf. And I do think that, it's going to, as, I think Ms. Plesha in her opening statement pointed out, that creates uncertainty, right? That creates uncertainty for customers. That creates uncertainty for the parties as to what really the commission's, thinking is a reasonable approach. While I don't think the commission needs to nail down and prescribe these are precise, allocators that need to be used henceforth and forevermore, I think with this divergence, it would really benefit the parties to just have some direction and guidance that kind of sets the course of what this current commission thinks is reasonable.
That's all I have. Thank you, Your Honor.
Thank you. Any questions from Sierra Club, MCU, or NAACP?
No questions, Your Honor.
Thank you. Any questions from Consumer Council of Missouri?
Yes, I have a couple.
Go ahead.
Good afternoon, Mr. Wills.
Good afternoon.
John Kaufman on behalf of Consumers Council. I just wanted to clarify Ameren, Missouri's perspective on the degree of customer choice that's available for the various time of use options. I guess, first of all, I'd ask you, do you believe that it's preferable that customers have an array of options as far as time of use, rate structure, or different rate methods?
Yes, I do. I think in our 2019 case, we brought forth the proposal to have rate choice for our customers, and we think that's, a positive thing for our customers.
Would you agree with me that it's preferable that customers have the ability to opt in to plans and that you have evidence of a customer's affirmative action choosing a plan before they're placed on it?
I think particularly for rate plans that could have significant bill impacts on customers, I think that's the case. I mean, I think we have two rates that are really close in alignment right now between the anytime user and the evening morning savers. In that, I think what we're doing there is reasonable. I mean, customers are not exposed to really significant bill impacts between those rates. But to the extent that, there are more advanced time of use rates with larger pricing differentials and larger potential bill impacts, I do think that I would have significant concern about customers, being defaulted or mandated onto some of those rates.
That's generally the direction I was going with my questioning. And to be clear, you would characterize what's called the morning evening savers rate as having as having a comparatively small differential.
I think that's a fair characterization, yes.
And is the fact that differential is small, does that inform your opinion as to why you think it's okay to default AMI customers to that rate as opposed to requiring an opt-in authorization?
Yes, it does, because I think we know with the evening morning savers rate that the bill impacts for customers are going to be, I'll characterize them as within less than 1 or 2%, plus or minus. When you start to look at the more advanced rates, and if you opted or defaulted a customer directly to one of those or mandated that, just for an example, on the smart savers rate, I think for 10% of our customers, you'd see a greater than 10% plus or minus deviation in their bills. So when we're talking about bill impacts for customers coming out of this case and having potentially a 5% increase, it could be 3 times that high for an individual customer on a smart savers rate plan. And I think moreover, I would say that for customers that use a lot of electric space heating in the winter, it could be even more extreme, really. And you could see customers, I'd say, 10% of customers in the winter, plus or minus 20% on their bill.
So even with the education that Ameren, Missouri has provided to its customers, you receive some complaints from folks who didn't realize that they were being defaulted to the morning evening saver plans.
I'm aware of some. Particularly your witnesses, attached a letter there. Certainly, I think we've seen certain, social media commentary on it here and there. I'm not aware of, broad dissatisfaction with it, but I have seen some.
But based on your experience, would you expect many more complaints if the commission were to default people to one of your other time of use plans with wider differentials in them?
I would, based on the bill impacts that I just described to you. I think that there would be significant concern that we might all see a lot of complaints about that we'd have to deal with.
And that would be, I assume, because you would expect several customers to get bills that surprised them. Were very different than what their other rate impacts were.
Right. If there were such a default rate, I'm sure, we would do our best to inform customers about that. But I'm sure there would be surprises to customers, and they would be, hit their pocketbooks pretty hard without some of them being aware or expecting it.
Well, given that, I think we have a similar perspective on, trying to avoid, surprise bills or shocking bills to customers. What are some of the steps that Ameren has considered for educating customers and making sure that they have all the information that they need to make a decision about these other more time of use plans with larger differentials?
Sure, yeah. I think as we roll out our AMI meters and customers get access to time of use rates, we have kind of a staged sequence of communications that go out to customers. But along with that, we've built what we call rate comparison tools, where customers, can evaluate what, based on their personal load profile, what a particular rate plan would mean for them. And those, and we kind of stage customers through this and ladder customers through kind of an educational process with that. When they first are presented with bill comparison, it's just for the evening morning savers and the anytime user to say, okay, you're going to go on this rate, and this is how it compares to the rate you've been on. And we let them know that there exist other rates, but we don't try to push them to those by kind of a push notification, so to speak, in any form or fashion. We wait for them to have that curiosity about the rate options and go out and look at the rate comparison tools to evaluate, okay, how might I save money on some of these other rate plans?
And at least as currently your rate switching tool is designed, it's designed not to switch someone over unless they affirmatively take an action, click a box or take an action.
Other than the evening morning
correct?
savers rate, they do go to automatically. But for those rates that we were just kind of talking about, that's correct. They have to call into the call center or make an online selection affirmatively.
Well, would Ameren, Missouri commit that if, going forward, that it would only propose plans where customers had the right to opt in if those plans go further beyond the differential in the evening savers rate?
I mean, I think when you talk about commit going forward, I don't know what kind of time horizon you're talking about and what we're thinking. I don't think there's any intention for us to propose any plans that would do what you're describing.
And Ameren, Missouri is on this, takes the same position that Consumers Council does as far as leaving the anytime rate as an option.
Absolutely, yeah. And in fact, we've got, as of the time I wrote my surrebuttal testimony, I think it was well over 50,000 customers who had affirmatively elected to go back to the anytime user rate. And I think it would be particularly frustrating to those customers who had been told that they had a choice, made that choice, and then to be told that they no longer have that choice going forward.
And would you agree with me that there are several customers who have a lifestyle or in a living situation where an anytime rate is the best rate for them?
I'm sure that, yes, I think there are some customers like that.
And would you agree that there might even be safety concerns with, for instance, seniors who need to use electricity during the day or might have their health dependent upon heating or cooling?
I think I see where you're going. I think maybe if the customers didn't fully understand it and overreacted to something, but I do think that on any of our rates, I think customers can operate their households safely. So, but someone who doesn't understand and maybe overreacts might avoid some heating or cooling that would help them. But.
And let me ask you about the names of some of these plans. You have the Ultimate Saver and the Smart Saver plans. It seems like all these plans have the word saver in them. Isn't it true that for these plans to actually result in a savings for customers, the customers have to understand what the terms of the plan are and change their behaviors and react to it to receive the savings? Is that fair?
Not for all customers. Some customers, naturally, their lifestyles will align with those rates. But for the universe of all customers, there are certainly customers that would have to take an action and change their behaviors or their lifestyles, their energy consuming patterns. So I wouldn't say universally that's true, but it's true for many, many customers.
In general, would you not agree that time of use plans are generally intended to change behavior or encourage changes in behavior by customers?
I believe that is one of the intentions of them, is to send price signals that hopefully customers will take actions that change behaviors to the benefit of reducing peak demand on high demand times on the system.
And given that is an expectation, would you agree that if a customer is affirmatively choosing a particular plan, they're more likely to react to that plan and to make changes in their life that are modified by or informed by the terms of that plan?
Absolutely, and I think actually Dr. Ahmed Faruqi, who we had presented as a witness in our last two electric rate cases, has research that, verifies that, and I understand that to be the case, that across other utilities, it's been found that opt-in rates produce greater response from customers.
Fantastic. That's what I was looking for. Thank you. That's all the questions I have.
Thank you. Any cross-examination from public counsel?
No, thank you.
Any cross-examination from the commission staff?
Yes, Judge, thank you. Good afternoon, Mr. Wills.
Good afternoon.
You don't look excited to be here.
I don't?
Hard to imagine. Let's see. Hypothetically, let's pretend that I'm a customer in Ameren, Missouri's LGS class, and I want to see how much energy I used last month in the hours from 1 p.m. to 9 p.m. Is that something I can look up online or get a report about from Ameren?
Not today. There are things that we're looking at to be able to provide that to customers, but today that's not available to the LGS customer.
Okay. Let's pretend that as part of the rate modernization, that's hard to say, process, everyone agreed that they wanted to charge a particular amount, or they wanted a charge for a particular amount for energy between 1 p.m. and 9 p.m. during summer billing months. Now, Ameren, Missouri has hourly load research data available. Is that correct?
We have hourly load research for sample customers in our load research sample. Is that what you're asking?
Okay. Yeah, it's close enough. That data, though, that you said you do have is done by calendar month rather than by billing month. Is that correct?
Well, it's done by hour, so it could be done load research data is hourly, so you could do it by any, aggregation that you wanted to, really.
Do you have class level data by billing month?
Class level data by billing month. Are you again talking about hourly data?
Yes.
No, not readily available. Now that'll be building with those customers that have AMI meters. We are capturing their hourly data, but for the entirety of the class, we don't have such data at this time.
Okay. Does the data that you have, the hourly data, tie to specific customers?
Yes.
But you don't have class data for all customers, correct?
We don't have the population, we don't have interval data, hourly data for the entire population of customers. And I guess by extension, we don't have the summation of the class by hour. We do, we do have the load research by class. We have interval data by class for AMI metered customers. We do not have, I think what you've asked there, I think the answer is no, we don't have that at this time.
If we need to know who, or we do need to know who a specific customer is to work out the relationship between that customer's usage between 1 and 9 p.m. and that customer's billing demand for that month, right?
Could you just say that one more time?
Sure.
Want to make sure.
We need to know who a specific customer is in order to work out the relationship between that customer's usage between 1 and 9 and that customer's billing demand for the month, right?
I almost think the question answers itself, that to know for a customer, yes, you have to know who the customer is, I think, yeah.
Okay. How long will it take and how much will it cost to program the billing system to do staff's overlay recommendation? And when I say overlay, I mean the one recommended in this case.
I don't have a specific estimate, but the kind of the benchmark that I included in my testimony was when we went through a similar process for residential rates. And now that was there were, multiple rates and there were multiple things going on with communication paths. But my testimony has that information. It probably speaks for itself better than my memory off the top of my head. But there, it was a period of months and I think it was hundreds of man-hours of employee time to program the rates.
Do you remember which of your testimonies that was direct rebuttal, sir, rebuttal that was in?
It's definitely not direct. I think it's rebuttal.
Slightly different question, but somewhat related. How long will it take and how much will it cost to program the billing system to do the rate modernization that you have in mind for the non-residential, non-lighted classes?
We haven't proposed anything specific for those classes yet. I mean, I think that's what the purpose of the workshop is for. But my guess is it would be a similar scope and timeline that for either rate that, for a rate like staff has proposed in this case, or a rate that may come out of that workshop or any proposal. I would imagine it would be a similar timeline, but until I know the details of those rates, I can't say with any certainty.
Okay. If I could. Forgive me, Mr. Wells, I'm trying to find which batch or which batch of testimony. Yeah, on page 24 of your SIR rebuttal.
Give me a moment just to get there.
Okay.
Okay, and I've gotten there.
Yeah, page 24, SIR rebuttal, beginning on line 3. You state that staff seems content to inappropriately set aside traditional embedded cost principles in examining production cost allocation in the class cost of service process and in time of use rate design in favor of focusing almost exclusively on marginal costs associated with the company's involvement in MISO. Did I read that correctly?
I believe you read it correctly, yes.
Well, I can still do something right. That's good. Mr. Wells, you've just been handed something I probably should have marked as an exhibit, but I didn't. Could you read the title and publisher identified on the first page of what you were just handed there?
The paper says Electric Utility Cost Allocation Manual, National Association of Regulatory Utility Commissions.
Now, I will represent to you that what you've been handed is the cover sheet, the table of contents, and page 108 of the 1992 NARUC Cost Allocation Manual. Does that look accurate, sir?
I've seen the manual and it looks like this.
Looks like that, all right. Would you please confirm for me that Section 3 of the manual is titled Marginal Cost Studies?
That's what's on page 108 that you've shown me here. Yeah.
Okay. And that marginal cost study section is listed as spanning 3 different chapters. Is that correct, sir?
It shows that chapter 9, 10, and 11 are included in this.
And how many pages are shown as being included in the marginal cost study section?
I don't see any indication of the number of pages.
If you turn to the table of contents where marginal cost study section is first listed and then through the to the next section.
Well, it looks like chapter 9 begins on page 109. Chapter 10 begins on page 127. Chapter 11 begins on 147.
Okay. So there's several pages, would you agree, of the neighborhood cost allocation manual devoted to the topic of marginal cost studies?
Yeah, not as many as right above that are devoted to embedded cost studies, but there are several pages.
It's certain marginal cost studies certainly don't look like a left field type of study based on the neighborhood manual there that the amount of pages devoted to it. Would you agree with that?
They don't seem like left field. No, I think their marginal cost studies have been used in the industry.
And accepted?
I don't specifically know of places, but I would not be at all surprised if that was the case.
Okay. Do you believe that the Smart Savers, Ultimate Savers, or Overnight Savers rate plans encourage customers to use more energy at times when the rate for energy is lower?
I don't know that they encourage them to use more at those times, other than if it was an offset to something they had shifted out of, a higher usage time, in which case the total usage may not change. So, I mean, certainly it would encourage customers to shift usage to that time, I guess I would say.
So is it not your position that it encourages more usage during that time?
I guess it's not my position that does then.
Is it your belief that the Ultimate Savers, Smart Savers, and Overnight Savers rate plans each cover the marginal cost of service and make a contribution to covering the company's fixed costs?
Over time, are you talking about, or on any given hour, or on what time scale and what parameters are you?
At the rates contained in the tariff.
At the rates contained. Can you ask the question again?
Sure. Is it your belief that the Ultimate Savers, Smart Savers, and Overnight Savers rate plans each cover the marginal cost of service and make a contribution to covering the company's fixed costs?
I mean, over a long enough time scale, yes. On any of our rates, I don't know that they do in shorter time scales, because those marginal costs can vary widely. Sorry, not wildly, but I guess occasionally they're wild, but they can vary widely on short time scales, but on longer time scales at kind of current energy market environments, yeah, I think they do.
Let me limit that to my question there too. Over the course of an average year, would you, is it your belief that they each cover the marginal cost of service and make a contribution to covering fixed costs?
I guess the only caveat I would say is that in the future, things can, change, but in the current energy market environments, that is my expectation that they do.
Mr. Wills, you've been handed what I will represent you as your charge ahead, your testimony, surrebuttal testimony in the charge ahead case, which I forgot the case number. That's ET. Well, could you just read from the first page there? Tell me what you've been handed.
ET 2018-0132.
And it is. Do you recognize it as your surrebuttal testimony from that case?
It looks like it.
All right. If you would turn to page 39. Line 13. You see the question that begins, Ms. Lange also discusses the possibility of time of use rates.
I see the question.
Okay. Would you read that question and answer? This is actually your question and your answer from that case, correct, sir?
As I read it, I assume that you've handed me that. As I read it, I'll determine that, but I think so. So you said you wanted me to read the question and answer?
Read the Q&A out loud there if you're the beginning on line 13.
Ms. Lange also discusses the possibility of time of use rates influencing the level of net revenue received by each charger. Is the potential for future rate design changes a good reason to delay the benefits EVs can bring to Ameren, Missouri's customers? Answer: no. The time of use rates that Ms. Lange discusses are generally implemented with the goal of changing customer behavior and altering usage patterns in a way that reduces the cost to serve those customers' load. To the extent that customers are able to charge at a cheaper rate and therefore provide less revenue to the utility, it should be because the incremental cost of serving them is also going down as a result of the actions they are taking to do additional off-peak charging. My expectation is that no TOU rate is likely to be established that doesn't fully cover the marginal cost of service and make a contribution to covering the company's fixed costs, so that those customers that do charge during off-peak times will still provide positive margin when netting the reduced revenues with the reduced incremental costs of serving EVs.
And just so the record's clear, Mr. Wills, in that passage of testimony, you used the abbreviation EVs is used. What's that stand for?
Electric vehicles.
And the additional, what was the other thing I wanted to ask you about? I guess that was it, sorry. Now, in your surrebuttal in this case, the 0337 rate case, you appended a portion of your direct testimony from ER 2019-0335, but only pages 23 through 42 of that old testimony. Is that accurate, sir?
Subject to checking the page numbers, but I did do that. Looks like page 23 to 42 is what I see.
You won't put that in. Okay. Judge, I would ask that a complete version of Mr. Will's direct testimony from ER 2019-0335 be, you take official notice of that so that we can have that in the record for this case.
Give me that number again, please.
Yeah, it's the rate case ER 2019-0335.
And that's Mr. Will's direct testimony?
Mr. Will's direct testimony, yes.
Is there any objection to the commission taking official notice of that? I hear none. The commission will take official notice of Stephen Will's direct testimony in ER 2019-0335.
If I may clarify, the charge ahead case testimony, was that going to be presented as an exhibit or is judicial notice taken of it? I was unclear.
The what, the charge ahead? Oh,
The testimony that you provided to Mr. Will? and-
no, that one's, I'm done with that one. He read it into the record. All right. The testimony that was just taken official notice of. Mr. Wills, you're being handed a copy of your direct testimony from ER 2019-0335, the case that the judge just took official notice of that piece of testimony. You're going to take a few seconds, quickly confirm that is your direct testimony from that case.
It does look like it.
Okay. Now, on page 42, you begin a discussion of the EV Savers rate. And by the way, the EV Savers rate is now known as the Overnight Saver Service Rate Plan. Is that correct, sir?
The rate that we originally proposed as EV Savers was renamed the Overnight Savers rate.
At page 51 of that testimony, you provide a table. And that table shows your analysis of the bill impact that changing to the EV Savers rate would have for 800 customers without any change in their behavior or usage.
I'm sorry, what, could you go tell me what page?
Sure,
you were
it's
looking at?
page 51.
Okay, I see page 51. Can you
Okay.
repeat your
Now,
question?
would you agree that the table on page 51 shows your analysis of the bill impact that changing to the EV Savers rate would have for 800 customers without any change in their behavior or usage?
I'm just reviewing the context of it. Yes, I think that's what that shows.
Okay. Now, the table also shows that not quite 200, but close to 200 of those 800 customers would see a bill reduction of up to $25 a year without changing anything. Is that correct?
Almost 200. It's hard to see what the precise number is, but
Right, okay.
we'll round it.
And the table also shows that a little over 100 of the 800 customers would see a bill reduction of between $25 and $50 a year without doing anything, without changing any behavior. Is that correct?
I believe that's correct.
Okay. And further, the table shows that another 25, roughly, of the 800 customers would see a bill reduction of more than $50 without doing anything. Is that correct?
Yes.
Okay. Now, if you want to turn over to page 57, I don't have a line number to give you here. I apologize. On page 57 of that testimony, you state, quote, "In reality, approximately half of all of the Ameren, Missouri residential customers would be able to save money under the pilot TOU rate without making any behavior changes at all," end quote. Do you see that, sir?
I do see where that is, and I would just note that we've moved into the discussion of a pilot rate we were proposing in that case. So it's no longer, this isn't applicable to the EV rate that we were just talking about.
Regarding that pilot rate, sir, you agree that that pilot rate is now the ultimate saver rate?
Yes, I was just trying to clarify that we kind of made a break from the prior, so that, it's clear that we're not.
But it's still one of your TOU options.
Yes.
Okay. On page 68, let me know when you get there.
I'm there.
Okay. You state, quote, "I analyzed a scenario where all customers that, based on their actual historical usage patterns, would have been able to save more than 5% on their electric bill by switching to the Smart Savers rate and then this is adopt it. Excuse me, I'm missing part of it. Do you see where I'm reading from, sir?
I do.
Okay. Could you, beginning there where I was, could you read through?
Yeah, I think that my sentence didn't grammatically make sense, is why you were struggling with it there.
Okay.
I think I had some bad grammar in a sentence. So.
Yeah, beginning with "I analyzed a scenario." Would you read that to the end of the? See where it says would be approximately $68 per year.
Yeah, I see that.
Yeah, read that into the record if you would, please, sir.
I analyzed a scenario where all customers that, based on their actual historical usage patterns, would have been able to save more than 5% on their electric bill by switching to the Smart Savers rate, adopt that rate after they receive an AMI meter. Of the sample customers, 27.4% fall into that category of saving 5% or more. The average savings on the Smart Saver rate for those customers, with no changes in consumption pattern at all, in response to the price signal reflected in that rate, would be approximately $68 per year.
Thank you. If you turn back 2 pages to page 66, you state, quote, "Because the rates are being offered on an opt-in basis, and the company is planning to provide education and tools for customers in order to help them make informed decisions about the best rate for them, bill impacts are generally expected to be favorable on balance for customers." Parenthetical, i.e., customers will opt in if they're likely to save money. Close parent and close quote. Now, if you turn to page 67, just one page over, beginning on line 3, would you read the question there?
Question: why are opt-in rates particularly prone to causing revenue erosion?
And then the answer. Yeah, go ahead.
The full answer? It looks like it goes on for a while. Do you want to go for over a page and a half? You want me to read the whole thing?
Read up till you get to the regulatory lag.
Okay. You can stop me if I don't get it the right place.
Okay, I'll jump in.
Answer: this is true for 2 reasons. First, the rate design changes proposed in this case are designed to be revenue neutral for the class as a whole, i.e., for the average customer. However, most customers are not average. None of them are precisely average. Every customer could naturally be a winner or loser on a new rate before making a single behavior change in response to the new rate. This is not a bad thing as long as the rate is aligned well with the cost of serving customers. The bill changes that create the various customer outcomes should generally be moving customers' bills closer to their true cost of service. This is generally a good thing, to be sure. But because the company intends to work with customers to help them make informed rate choices using enhanced usage information from AMI meters, adoption should be very asymmetric. Expected winners should adopt new rates readily, realizing bill savings that reflect the lower cost of serving these customers that generally have more favorable load characteristics. Customers whose rates are likely to increase under the new optional rate structures due to inconsistent loads with peakier usage may simply choose to stay on the status quo rate. Therefore, the revenue erosion caused by bill savings of adopters will not be immediately offset by increases for others. I would note that this revenue shortfall should be made up in a subsequent rate case, so the issue I'm addressing is really one of regulatory lag.
Thank you, that's where I wanted you to read to right there. Now, in that case, you made the statement in the context of, in that case, Ameren, Missouri we what you called a rate migration tracker. Is that correct, sir?
We may have had a different name for it. I do think it was, we may have called it rate migration tracker. Certainly, we had a tracker that I think was analogous to the proposal in this case for the rate switching tracker. That may have been what we called it at the time.
And Ameren, Missouri concluded that case without receiving the tracker. Is that correct?
In a settlement where the totality of the settlement was, acceptable to Ameren, Missouri, we did.
Okay. And you also concluded that case with a number of time-based opt-in rate plans, correct?
That is correct.
Okay. And in fact, both of those items, or well, I shouldn't say both, the case was concluded by the signing of a stipulation and agreement. Is that correct?
Yes, that's my recollection.
Okay. Do you have a copy of your direct rebuttal and surrebuttal from this case with you on the stand?
I do.
Okay. If you turn to your surrebuttal, page 6. That's right.
I'm there.
Yeah, okay. On line 7 there, it says, you ask yourself, what are the reasons staff gives for the recommendation, excuse me. And your answer begins, first, staff suggests that the company has not quantified the benefits to all customers of an individual customer's decision to take service on, on a time of use rate and potentially shift its usage away from peak periods. Did I read that correctly, sir?
Yes, you did.
Okay. Now, looking at your direct, your rebuttal, or your surrebuttal, can you identify a page and line number where you quantified the benefits arising from the shifting of usage away from periods of high demand and therefore higher costs on the system?
I'm sorry, could you say the question one more time?
Sure. Looking at your pre-filed testimony in this case, the direct rebuttal and surrebuttal, can you identify anywhere in your testimony that you quantified the benefits arising from the shifting of usage away from periods of high demand and therefore higher cost?
I don't believe that I have that addressed in those pieces of testimony.
Okay. But the reason I'm asking, you're criticizing staff there on page 6 for not quantifying certain benefits, and yet you have not quantified what you claim to be the benefits either. Is that correct?
I was criticizing staff for saying that there are no benefits. I think that was a slightly different thing.
Well, if that's what you were criticizing staff for, why do you say staff suggests the company has not quantified the benefits? Why do you even talk about staff
I was just
quantifying the
summarizing
benefits?
this question and answer. I was just summarizing my understanding of a position.
Let's see, your surrebuttal there on page 6 continues with, quote, suggesting that the promotion of time of use rates may not be beneficial for all customers, and by logical extension that the commission should not even want to encourage more time of use adoption. That would be lines 10 through 12 on page 6. Now, where does staff say that in its testimony? Because you don't refer to any specific testimony or line or page of staff there? Where'd you get that?
I mean, I don't know, sitting here without that testimony, if I can recall like the exact statement that I was referring to. I think that was my perception of the staff's argument. I'd probably have to take some time to read all the staff's testimony to find any particular quote that gave me that perception.
Okay, so you're not saying staff actually said these words. You're saying that staff said something that triggered this thought in your mind and for your interpretation of what staff had said.
Well, I mean, I think the overriding factor that made me say that is that staff was saying that there's no evidence of benefits from time of use rates, or there's no evidence, right? I didn't say, but if that is the reason that we shouldn't have a tracker, then there must be a presumption that there are no benefits, because I think this commission has kind of articulated that they think time of use rates are beneficial. So to say that benefits are not a good reason to create a tracker, I just...
Are you talking about benefits of the rate, or are you talking about benefits of the tracker?
Benefits of the rate.
Okay, but you see the difference between benefits from the rate or benefits from the tracker?
I know there's a difference between those benefits. I may be lost even the context of the question about what you're asking me there.
Well, it would be possible to have benefits arising from the time of use rates, or from the adoption of time of use rates, and not have any benefit from a tracker. Would you agree with that?
It could be possible. It could be possible that there are benefits arising from a tracker.
So that's my point. I mean, the benefits of one do not necessarily correlate with the benefits of the other.
I think if the alignment of incentives exists through the existing of a tracker that causes the company to take, more creative approaches to getting more customers on a rate, if the rate is beneficial, there will be more of those benefits that arise from the tracker that gave us the alignment of incentives that got us to take the action that brought in more time of use customers. So they're not one and the same, but I think they are very, very related.
Okay. Now, in your direct testimony, if I could have you switch over to that.
Okay.
Testimony or the charge ahead order? Yeah, so here's a copy, so it's the order, okay. Okay, I figured out what I'm doing. Okay, on your, in your direct testimony there, you refer to the commission's charge ahead order, do you not, sir?
I mean, I probably did, but I don't know where in my direct testimony
Okay.
that you're talking about.
Okay. Well, you've just been handed a copy of what purports to be the charge ahead order. Does that look familiar to you, the charge ahead order?
The cover page certainly looks like it.
If you turn to page 29 of the order, and by the way, Judge, this is the commission's order in case ET-2018-0132. Page 29, Mr. Wills.
Yes, I'm there.
4 lines up from the bottom. It reads, quote, "Further, by allowing the opportunity for Ameren to request the non-rate-based treatment in a future rate case and retain any electricity sales revenues between rate cases, Ameren, Missouri, and the customer's interest in the program become aligned. Thus, it is in the public interest to authorize a deferral accounting mechanism or tracker, close quote. You see that?
I see that.
Okay. Now, when the commission refers to Ameren retaining electricity sales revenues between rate cases, that's what we traditionally refer to as regulatory lag, correct?
I think that's a fair characterization.
Okay. So in this order, the regulatory lag issue was Ameren, Missouri collecting revenue from KWH sales that had not yet been recognized in a rate case.
Can you say that again?
Sure. In the ET order, the regulatory lag issue was Ameren, Missouri collecting revenue from KWH sales that had not been recognized in a rate case yet.
And using those to offset the costs that the company was voluntarily incurring as a result of the program, so to kind of make us whole for that. But yes.
Well, I'm focusing on the regulatory lag aspect of it. You would agree with my description of the, okay.
Yes.
And the commission found in that order that the alignment of Ameren, Missouri's interests and the customer's interests was going to come from Ameren getting extra revenues between rate cases and customers getting those extra revenues recognized in rate cases.
I think that's a fair characterization.
Okay. But in this case, you're arguing that Ameren, Missouri needs this tracker because Ameren, Missouri is not getting the amount of extra revenues between rate cases that it believes it should get.
I think this is a totally different issue than the revenues that arose from the charge ahead case. The charge ahead case was related to us incentivizing customers to put in EV charging that we hoped would cause additional EV adoption in our service territory and create revenues that would help pay for the charge ahead program financing costs. In this case, we're talking about revenues, existing revenues of customers that will decline because they're shifting load and saving money on time of use rates. I think those are just different buckets of revenues that are being addressed by the different trackers.
But you would agree we're both trackers.
Well, one is a tracker and one is a proposed tracker, but yeah.
Right.
Yeah.
And so you're saying that in the one case there, the commission found that regulatory lag was to the Ameren's benefit between rate cases, and then the customer's benefit during the rate case. But you're in this case, if I understand correctly, you're saying that Ameren needs the tracker because Ameren isn't getting the extra revenues between rate cases that it believes it should get.
No, we're getting a reduction in what would otherwise be existing revenues.
Well, that's the revenues you believe you should get, right?
I believe that those revenues provided an opportunity for us to recover the revenue requirement that the commission would approve in this case.
Do you believe that the revenue erosion needs to be paid for by ratepayers? What you term revenue erosion in your testimony needs to be paid for by ratepayers?
I believe that amounts that are collected under this tracker should be reflected in the revenue requirement in future rate cases, and rates should be based on that. So if that's how you would characterize that.
I think that's all I have, Mr. Willis. Thank you very much.
Thank you.
Any commission questions?
Judge,
Hey, Judge.
Commissioner Holzman. Oh, go ahead. Go ahead, Chairman.
No, go ahead. Go ahead, Commissioner Holzman.
If you can both hold on just a second, an attorney's trying to get my attention.
I'm sorry, Judge, I might have been passed over. I have a few questions for, Renew Missouri, that is, has a couple questions for the witness.
You were, and I apologize.
That's
for
okay.
that.
I'm happy to
sorry.
let the commission go if you'd like to.
Can the commission hold their questions for just a second while I let Mr. Linares ask his questions?
Of course.
Absolutely.
Thank you very much, commissioners and chairman. I apologize. I did skip right over you, and I did not mean to do that. Go right ahead,
That's
Mr.
perfectly
Linares.
fine. That's perfectly fine. Afternoon, Mr. Wills. How you doing?
Doing well, how are you?
Just fine. I just have a few questions here on the time of use question. And I'm in your direct testimony, if you have a copy of that, at page 9, if you'd like to follow along.
Got a lot of paper here, but I think I found it.
Okay, okay. I'm looking at the bottom of page 9, starting with however. Do you see that?
I do.
So you state that time of use rates can be a valuable system planning tool to help reduce peak demand and capacity needs, integrate levels of intermittent renewable generation, et cetera. Do you see that?
Yes.
My question is about this issue of intermittent renewable generation. Are you familiar with the concept of what's referred to as the duck curve?
I've heard of the duck curve. I think I know
Okay.
what you mean by that.
Okay. Can you explain your understanding of the duck curve?
Sure. The duck curve, I think it was most noted in California when there was a large increase in customer-owned renewable solar rooftop generation. The interplay of solar generation and customer load. If you looked at the daily load profile, kind of hour to hour, I'm trying to figure out how to describe this without being able to draw a visual or something like this, right? But as load increased in the late afternoon, generation was also going down because the sun was getting lower in the sky and there was less generation available. And what had ended up happening is the load curve had a very extreme pickup that kind of looked like the neck of a duck. The load shape for the day looked like a duck. The duck curve basically, we talked about, was the problem late afternoon when the sun was in decline, generation was declining, load was still increasing or at least remaining at high levels, and there was a rapid ramp up of dispatchable resources needed during that time frame. I think,
Yeah.
is that what you're looking
Sure.
for?
It would be fair to say that the increase in solar and its production in the middle of the day doesn't necessarily align with the system peak, and it results in a more dramatic difference in peak. Is that fair to say?
That's the duck curve theory, and I
Yeah.
think that there's some evidence or merit that can happen.
Yeah. And you would agree with me, and I think your testimony states that the coming transition on the grid is going to result in a more significant increase in renewable energy, specifically solar.
That would be my expectation.
You go on to say, this is top of page 10, we're mindful of the ability of time of use rates to be one piece of the complex puzzle of reliably integrating large amounts of renewables and eventually retiring existing dispatchable fossil fueled resources. Do you see that?
Yes, I see that.
So my question is, has the company or have you yourself studied the potential for encouraging, say, west-facing solar? That is, solar that would produce later in the day and have more of a system peak offset, and using rate design to accomplish that. Have you studied that issue?
I'm not aware that we've specifically studied west-facing and encouraging that through rate design.
How about using solar plus storage to accomplish that?
I certainly think in an IRP we're studying that certainly at the utility scale. I think the applications on customer-owned are at a different scale, but they would have a similar type of effect as that potentially.
Okay,
That's what you're getting at.
a little wrinkle on that question. How about using rate design to encourage the adoption of solar plus storage on the grid? Have you studied that?
We have not specifically studied that, no.
Okay. A little bit further down that page and then on to page 11, you state, you talk about the current demand side management potential study that's ongoing. Is that right? The DSM potential study? Yeah.
Yes.
And on page 11 there, you state, by completing thoughtful analysis of DSM potential, including time of use rates and reliability modeling in the context of ongoing IRP efforts that aim to ensure a reliable transition to cleaner renewable energy sources, we expect to determine the appropriate role of time of use rates can play in managing the generation transition. And my question here is, in the context of the demand side management potential study, have you studied how rate design might be used to encourage things like, say, electric vehicles, for one?
I don't know that we've ever got a specific study of electric rates encouraging vehicles themselves. And I don't have at my fingertips a full, recollection of every measure and scenario that was analyzed, but I imagine load shifting on electric vehicles is probably, I think it was in there. I didn't read it, coming into this and review it in preparation for today, but and really that study is still,
being wrapped up in draft form. So I guess my answer is, well, could you repeat what the question
Sure.
was actually?
Let me back up. Have you worked, could you describe your work on the demand side management potential study? Your involvement?
I haven't had a particularly hands-on role. As Director of Regulatory Affairs, I've been in a number of meetings where,
Okay.
The topics are discussed and
Okay.
have some awareness of it.
So we're speaking about your awareness in these meetings, your general awareness of the DSM potential study,
Right.
what's included in there. So my question was whether electric vehicle, whether rate design has been thought of as a tool to increase adoption of electric vehicles.
I don't specifically recall that being included in there, but I wouldn't want to categorically say it's not possible that it has been.
But would you agree that electric vehicles could be a tool to accomplish load shifting with the right behavioral
I mean,
incentives?
certainly electric vehicles are a load that I think has a lot of potential to be flexible in terms of the timing of when you charge vehicles. And I think if electric vehicles are on the system, load shifting is a good thing to pursue with those, if that's what you're getting at.
Regarding this DSM potential study, does it include any analysis of using rate design to encourage the adoption of battery storage?
Not that I recall. Not rate design I think there is study of, I think there's a study of battery storage. I don't know that there's an interactive component between rate design and battery storage in the study, but again, I'm speaking from a kind of a high level knowledge of a study that's just wrapping up. So I don't want to portray that as I have certainty that there's nothing in there on it, but I don't recall anything on that.
Okay. Another question in this line, are you aware of whether the DSM potential study analyzes using the ability to use rate design to encourage the adoption of rooftop solar or solar plus storage?
I'd say the same answer for battery storage.
Would you agree that battery storage is a potentially powerful tool in accomplishing load shifting and demand reduction on the grid?
Potentially, yes.
Okay, how about solar plus storage? Would that be a potential powerful tool in accomplishing those goals?
I think solar, and whether the storage is with the solar or not, I think storage has the potential to do that when solar is on the grid, so.
Okay. That last sentence of the first paragraph on page 11, following up on the line that I just quoted, it says, quote, "At that time, depending on findings, the company may develop more specific adoption goals and/or enhanced marketing strategies designed to promote adoption to the levels needed to achieve various objectives." Do you see that?
I see that.
Does the company, according to your knowledge, have any plans to use enhanced marketing strategies to promote the adoption of battery storage or solar plus storage or rooftop solar?
Not that I can think of specifically sitting here right now.
Okay. Okay, just I think a few more questions. I'm turning to your SIR rebuttal now, and I'm on page 21. And this is starting on, sorry, go ahead.
I still haven't found it. I have too much paper now.
I'll take some of it back and see what
Let me move this to the side.
I can quote you the line and let you catch up here. Page 21 at line 8. The question is around the parties working together to try and integrate time of use rates with distributed generation technologies, including net metered solar. And you say the company has sincere interest in making these rates available to net metering customers, but believes that is only appropriate if the proper statutory changes were made. Do you see that there?
I do.
So I think we're of the same mind there. I'm happy to hear that the company has that sincere interest around net metering and time of use rates. My question is does the company have the same sincere interest in making battery storage work with time of use rates?
I mean, I don't know that I've, just given it the discrete amount of thought to, to have a company stated position. But I think that we would certainly contemplate that as something to take a look at.
So you're not in a position to commit that the company would use battery storage to accomplish the same goals that you've stated?
I mean, my personal opinion is that would be of interest. I think the same concerns that we have with respect to net metering solar customers and the way the statute kind of addresses time of use are actually probably even more exacerbated with battery storage. But if those issues were resolved, no, I think that battery storage could be something that would be beneficial and could be promoted with time of use rates.
Well, there I'm going to have to clarify, because your concerns about net metering and time of use have to do with the net metering statute, correct? And it's around the statutory language in that law, right?
Our concerns have to do with the statutory language causing, because I think earlier in your opening statement, I think maybe we talked past each other a little bit, because you said that the statute doesn't allow us to offer these time of use rates. I think my rebuttal testimony says it doesn't allow us to offer them in an economically rational manner. Basically, the way the netting works under the statute, in my view, destroys the price signals of the time of use rates when you introduce these kind of technologies that can move load around. I don't believe that we've ever said that the law says I couldn't offer our Smart Savers rate to a time of use customer, but I've said that it would destroy the price signals and create an economically irrational outcome. The price signals just don't work unless you can do, I think you talked about what was going on in Virginia or in North Carolina, where you would be netting within off-peak buckets or on-peak buckets. If we believed that was legal, I think we'd be doing it.
Well, we very well may be talking past each other, because if that's your opinion, then I certainly misunderstood you. I'm reading your rebuttal here, and the question, your answer at line 6 says, conceptually, yes, if Missouri's net metering statute were different. However, it's not, and the kind of solutions witness Owen would likely want to see cannot, based on advice of counsel, be implemented without a statutory change. My understanding there is your counsel is instructing you with a legal opinion that it is not possible without statutory change. Am I wrong?
I might have you ask my counsel. I think that what I have understood and what I've testified to is that strict application of the statute does not cannot be done in a manner that time of use rates do what they're supposed to do.
Okay, well, I hate to dwell on this distinction, and of course, you're not a lawyer, so perhaps you're not giving a legal opinion, but just your understanding of what counsel has told you. Is that correct?
Objection.
Okay.
Don't want to get into privileged information.
Okay, I'm not asking about any communications between you and counsel, but I'm simply trying to get at here what your understanding of the statute is. You seem to be telling me there's not a legal impediment to doing it, but an economic one. Is that right?
A legal impediment to doing it economically, rationally, I think is what.
Okay. I'm not sure we're seeing eye to eye
It's the
there.
intersection of of what can be done legally and what it ends up doing to the rates is my.
Okay. Well,
and it, like you said, I am not a lawyer, and maybe I'm misrepresenting something as well, but.
Okay.
I was not misrepresenting, but misinterpreting something as well, but.
Well, I'm simply reading your testimony, so I'll give you a chance to correct that if you'd like to. Would you like to rephrase or change what your testimony says there? Because it seems to conclude that we cannot integrate time of use rates and net metered solar without a statutory change.
No, I wouldn't change that. The distinction there is the solutions. When I said, when I lost the page that we were on. Okay, I said the kinds of solutions that witness Owen would want to see, I think of as netting within off-peak, netting within on-peak, exclusively. And my understanding of the statute is that we have to net all kilowatt hours across the entirety of the billing period with each other, irrespective of whether they're in on-peak or off-peak. I believe, and my counsel will speak legally for the company if there's a legal question about it. But I believe that our concern is that you legally can't not net an off-peak kilowatt hour with an on-peak kilowatt hour. Because the law says any kilowatt hours produced across the billing period have to net with each other. So it's creating those divisions between the peak and off-peak where the netting is isolated, peak off nets with peak and off-peak nets with off-peak, that I think that we believe that we can't do is my.
Okay.
That's.
Okay, well, I think there's a difference in legal opinion there, but understood. Sorry to take us down that rabbit hole. I think it was worth clarifying. So regardless of net metered solar, which is what we've been talking about, I want to ask you about battery storage. And you say the company has sincere interest in making these rates available to net metered customers. My question is, given that sincere interest, do you have that same sincere interest about battery storage, which is not implicated in the net metering statute?
So when I'll give you my opinion, because when I say the company has sincere interest, that usually means a vetted position that I've discussed with others at the company, and I don't know that we have discussed something that I would portray.
Okay.
I think from my perspective as Director of Regulatory Affairs, I think that we would have interest in that if it worked economically rationally.
Okay. Okay. And to be clear, that's an interest in using time of use rates to encourage the adoption of battery storage.
Well, I would stop short of saying that rates should encourage, but I think that they should, I guess I would say, facilitate, customers who want to do that to create beneficial outcomes with it. I think I said somewhere in my testimony that rate design to me is not the tool that you use to encourage technologies. It's you create cost-based structures that because the cost-based price signal will tell that battery to do the right thing.
Right.
So, and maybe to some people it's a distinction without a difference, but I think it's important that the rate structure isn't there to encourage the technology. It's there to show the cost and then to get the technology to respond to that cost price signal and create beneficial outcomes. So I think.
But to be clear, the time of use rates currently, as proposed, do not offer that incentive.
I'm just trying to think about a circumstance where, I mean, I think there may be customers that if they have a battery that's completely behind their meter and they never export to the grid and we don't even know about it, they could shift their load that way, I think. If they're interconnected and want to be able to provide power to the grid, it would not, I think. That's the key.
Okay. Okay, I think that concludes my questions. Thank you.
Thanks.
Thank you, Mr. Linares. Chairman, you had some questions?
Thank you very much, Judge. And thanks, Commissioner Holzen, for letting me pop ahead here. So you've covered a lot here with your testimony. I did want to say, clarify that you stated that you have had 50,000 people that have left the TOU rate and went back to the anytime rate. Is that correct?
Yeah, it's over 50,000 is the number. That's in my surrebuttal testimony with a precise number as of the writing of that testimony, Chairman.
Yeah, I just wanted to clarify that I had that down.
Yeah, you heard right.
And what is the total number? Because I just literally got my letter last week that my smart meter will be soon installed. So what is the current number of people that I know you said you're about 2/3 of the way of installing those. How many residential households have those now?
Have the AMI meter?
Yeah.
I'm going to try to find a very close number, but I'm going to say it's certainly about 2/3 of our population. It's over 600,000. As of my surrebuttal testimony, I think I had a number in there, but I don't know exactly where to find it in the surrebuttal, but I think it's there.
Okay. Now that's the ballpark is good. And how many of those have had the opportunity to, like how long after having that installed is the change of a rate to a TOU rate?
So if a customer doesn't make their own choice, after 6 months after their AMI meter is installed, they will be, moved to the evening morning savers rate, which is a time of use rate. And at any time up to that point or after that point, they can move to any other time of use rate or back to the anytime users rate.
And out of the 50-some thousand that you've seen switch, have you broken that down in between? They switched prior to, like once they initially made their choice, and how many of those, were placed on a rate and then later on made a decision to switch?
I don't believe I've seen the numbers broken down in that way. Unfortunately, Chairman, I don't think I know the breakdown of that.
Okay. So you had stated that, like the point of TOU rates is to encourage, the consumer to take actions because of a price signal to change their usage, to assist with changing peak usage. Do you feel that 50,000 people, or roughly 10% of the people that have had that opportunity, have left the what did you call it, the slightly differential plan and went back to any time? Do you believe, or can you comment on, is that a result of there not being a strong enough price signal or any differential for change? So why bother?
I can't speak to any individual customer's decision, but I do think that there, maybe the best example to point to is the CCM testimony of Ms. Hutchinson that had a customer letter attached to it. I mean, that did not appear to be a circumstance where, the customer went back because the differential was too small. It appeared that they did not want to be on a time of use rate. They didn't want to have to, maybe they're, home all day and feel like, that's the time when they do certain activities, in the home. But every individual customer's motivation may be different. So it's hard to generalize, but I do think that there's at least some who don't want to be on a time of use rate for compatibility with their lifestyles.
Yeah, I understand. Yeah, that there are a lot of people that would choose not to because of their lifestyles. So the amount of the 50,000. So what is that in line with the company's projections of how many people would have switched that quickly, or were you surprised at the 50,000?
I don't think we had much of a basis to have a projection of how many would, but given that in my mind is, right around 10% of customers, it didn't really surprise me that there would be 10% of customers out there that would prefer kind of the known rate, the flat rate, that they know exactly, how their bills are going to be priced based off of their history and things like that.
Is that in line with experience in places that you'd studied in other utilities with a 10% switch rate in the first year or so?
I'm trying to remember if I have any good benchmarks on opt-out rates like that, and I'm really just not coming up with, at least off the top of my head, back when we proposed these rate plans, as I'm sure you recall, Chairman, when Dr. Faruqi was here, we looked at a lot of those other utilities. I'm struggling to remember a typical opt-out rate for opt-out plans. So sorry, I don't have a number or a benchmark for you on that.
No problem. That's why I was asking if you had one readily available. So switching gears, staff's, made several comments and verbal and written testimony about the inability or the refusal or the unwantingness of the company to provide them with the data that they need to, to more closely align customer class usage with cost. And I know that the counsel for staff had asked you how much, or asked you what the availability of gathering that data, and I think you said it would just basically be man hours. Do you have any idea how much that would cost the company to gather the data overlay that staff is requesting?
Well, I think it depends on, there's several different elements of data requests, and I think what we were talking about with staff earlier, if you're thinking of the exchange that I'm thinking of, related particularly to AMI data for customers. In that regard, I think it's probably not. I mean, I think we have been providing a fair amount of AMI data through our cases. The problem there is that we don't have complete deployment, so we don't have AMI data for all of our customers. But I think some of the question you're getting at gets to the class cost. You kind of mentioned the class cost of service data. That's about more granular analysis of the distribution system. Quite frankly, I think from one request to the next in the data requests we've experienced on that we've had challenges in answering, there's been a whole gamut of different types of questions, some of which we don't even think are possible to answer without, really maybe possible at all, period. There's a lot of interest in customer-specific infrastructure, and, we have 1.2 million customers, and, to do we have not seen like the construction of a study that we've been asked to do that looks like it could be done without, sending lots of people out into the field to, collect information about different pieces of infrastructure serving customers. And frankly, we don't exactly know what it would look like to collect and compile and put all of that together. Chairman, I think one of our concerns also is that the more granular of the data that you get down to, the managing that data into something meaningful to provide to staff and for staff to use in a study becomes really just almost unwieldy from our perspective. We believe our class cost of service study is already very detailed and very specific, getting into, voltages and at different types of assets. But the level of granularity that we've seen in a lot of the questions, we don't even really know how to report that data, what it looks like, how you compile it into managing a study. I guess I'll pause there and see if I'm answering your question. But
well, I mean, yeah, it was the exchange you had with the council, and they were talking about the hourly class data, and so wasn't that kind of the selling benefit of advanced meters beyond beyond automatic shutoffs and time of use rates? You can gather more data on usage, and then if you can compile that data into the class and use that to specify in a class cost of survey to get better data on who is using what when, because I'm getting the sense that staff in their class cost of service studies are trying to equate what classes are using what energy when, i.e. renewable energy during the day probably being used more by industrial class, and wind energy at night when most people are sleeping probably being used by some type of more of an industrial. So I believe they're trying to take that class and assign the cost of those facilities to that class more, and that's kind of where they're coming up with some of their differentials of who's using what when, but they don't have the data, so they're making assumptions, and then the company is questioning their assumptions. So the conversation that I think Ms. Plesha had, that you even referenced, the Ms. Plesha, is that you are looking for more guidance from the commission on class cost of survey and what are we thinking. And so without the data that can be compiled, it's hard for us to move forward. So my question to you is, what would the cost be? Not looking for a dollar amount, but if there was an incurred cost of man hours and writing code and data gathering, would whatever dollar amount, would that come out, would that be applied directly to the shareholders, or would that be borne by the ratepayers? So what would the true cost to the company's bottom line be for gathering that data?
So I do want to just clarify with you for a second, Chairman. I think the question is very different with respect to AMI meter data, which, and maybe I'm mistaken, but I don't think we have as much dispute with staff about providing AMI meter data. And I think, as we get all of our meters rolled out and develop more, just more internal processes with that data, I don't think that AMI meter data is going to be a significant problem. In fact, in this case, we provided quite a bit of AMI data. We also provided still load research-based hourly data that I think has a lot of the class level characteristics that AMI data would have. So I don't think that there's a big cost number on, if you're specifically referring to hourly data and AMI data for meter data. But there's a whole host of other data I guess, issues that are raised by staff that relate to distribution infrastructure. And that's what I was getting at, where I think the cost lies, is in getting extraordinarily granular and highly precise at the asset level statistics on the distribution system. You said who would bear the costs? I think, we would certainly incur those costs as O&M expense if they fell within a test year and a rate review. I would fully expect that they would be included in the revenue requirement in our rate case, and they would impact customers going forward. Certainly, if they happened outside of a test year for a rate case, the shareholders would be impacted by it. So that's just a kind of a regulatory lag question. But I do believe that, to provide the incredible granularity and specificity of statistics about distribution infrastructure would require, I don't know that I can actually tell you the number of man hours, but I think it would be very, very significant in terms of having a number of employees deployed for, probably months.
Okay, so if the cost will be, if it was in a rate case or a test year, or if we were to put some type of a tracker to track the costs, which could be included in a future rate case, which would then be absorbed by the ratepayers, so would not, come from the, from the company's shareholders, and it would take months, and you have to come in every 3 years under the PISA statute. Would the company, if they knew that it wasn't going to be impacting, their bottom line, and they would have up to 3 years to gather the data, would the company be willing to do the man hours and legwork to gather the data that staff is requesting, so as to advance us down the road of this class cost of service study issue? So the next rate case, we're not having the same discussion on let's use A&E, or no, staff has a novel approach again.
I absolutely think it would still be a novel approach if all the data were provided. That's the other point with this, Chairman, is the biggest problem for us is the methodological change that is being driven. I think staff represents that all of this data is needed, but I mentioned the more granular you get, class cost of service is like a puzzle, and if you break this down into instead of hundreds of pieces, you break it into thousands or tens of thousands or hundreds of thousands of pieces, the introduction of mismatches and biases in that data becomes significant. And then on top of that, we're just seeing choices made and the allocation factors made by staff that we're going to continue to say that there's a novel approach. And I think MIEC and MECG most likely, would feel similarly. So my biggest concern is that there's a cost associated with the data, and the benefit is actually not there, right? What's been portrayed that this data is the answer to getting a more accurate class cost of service, I see it making them less accurate, and I think it's a big driver of why staff's study is way out of line with kind of what the national average in terms of class rates would be. And I think the benefit would be a negative, in fact, to do that and try to do a class cost of service study at a level of granularity that is, it just, when you're down that far into the weeds, there's all kinds of opportunities for mismatches. You captured customer-specific costs for one class or not for another. You've carved out certain costs and assigned them to customers, but then you've allocated the remaining bucket using load that had the customers that had direct assigned costs, and you end up double counting. I just think that level of granularity is inadvisable in order to do class cost of service in a reasonable fashion.
So, see, I would take the opposite side of, we shouldn't do it because nobody else is doing it, so you're just perpetuating the status quo. And rarely in my life have I found that more data to identify, cost drivers and things produces a worse outcome. Now, yes, you can have an overload of data, but if you're going to go to, if you kind of have a tighter of what you're looking for, and then you can do that, more data tends to drive, a better process. Now, I am not saying that we would like the outcome. I'm not saying that Missouri would gather all this data and it might show stuff that we would be an outlier. And it might be something that, from a policy perspective, that the commission would not choose to move forward with. But I don't see us getting out of this, what I see as a perpetual pattern of future of saying, well, you got the large consumers saying, oh, we can't use this. This is the way we've done it. This is the way Neighborhood's done it. They got the 1992 manual and we're using it this way. And then if people approach it with a different saying, hey, we want more data, we have all this technology, we can do that. I don't see the negative of getting more data, and at least giving the commission the option, to weigh it, and let's argue over the data rather than argue over assumptions. And so there's not really a question there, but I just don't want to have another rate case 3 years from now, 6 years from now, where we're having the same concept when the cost to the company would only be man hours, and and they would have plenty of time before the next rate case. But I know I'm bumping us up here against our hard stop, and I know Commissioner Holzman had some questions, so I'm going to go ahead and stop there. And Commissioner Holzman, go right ahead, buddy.
Thank you, Mr. Chairman. And appreciate you taking a minute here to answer questions. I'll try to be brief, try to get us done by 5:30. I want to return to the line of questioning from Renew Missouri. The plain reading of the net metering statute, in my opinion, clearly says that rate structure shall be offered to net metering customers in the same fashion it's offered to everyone else. Your testimony and your comments and discussion with Renew Missouri is basically saying, but there's another statute that's saying that we can't do it because everything has to be netted out. Can you tell me what that statute is that you're referring to that would potentially say that you can't do it when the net metering statute in plain language says that you shall do it?
So it's the same statute, Commissioner. I think there's two things that I would point out with respect to this. First, I think the position that we've put forward is that the plain reading of the statute, at least my non-lawyer's reading of it, but I can read the words on the page, is that it says you have to offer the same rate that they would otherwise be assigned to, and that's what we've really done. Is the rate that a customer would otherwise be assigned to is our evening morning savers rate, and that is available. The other part of the statute, and I don't have the language sitting in front of me, but it essentially says you must net all kilowatt hours across the billing period. And what we're saying that needs to happen for an economically rational application of net metering of time of use rates to net metered customers is that netting should be segmented within time of use periods. And so the language that says that you must net all kilowatt hours across the billing period, I believe that if you have over-generation in the off-peak and you net it against consumption that occurred during the peak, that's destroying the price signal of the time of use rate. And what ought to happen is the excess kilowatt hours from the off-peak should be treated like, excess generation kilowatt hours are today. But the statute would tell you need to, as long as there's a consumption at least the way we've read the statute, there's another kilowatt hour in the billing period. It just happens to be in the peak period. And that netting basically allows you to take a low value kilowatt hour from the off-peak that was over-generated and offset a high value kilowatt hour of peak period consumption. And that basically just essentially destroys the price signal included in the rate.
Okay, it is not relevant to this decision-making. It's just an interesting fact that interpretations of statutes can vary and change. I happen to be the legislator who wrote that statute in 2007, so it's interesting to me that here we are, just casually 15 years later, discussing it and having a difference of opinion of what we think that it says. And that's just a comment, not a question. have you, when the line of questioning of discussion on the battery storage and dispatching it, in your studies or research, have you looked at virtual power plants and the concept of strategic geographic placement and dispatchment at times and place of the utility's choosing, so the utility almost becomes a mini RTO, in using residential meters to bank the storage, but would ultimately be controlled by the utility? Is that something that you have looked at?
I'm not a, so there is, you know, like as I was discussing with, I can't even remember who I was discussing with the market potential study, maybe it was Mr. Linares. I'm not, you know, deep into that study, so I'm not familiar that we have looked at it, but I can't tell you that there has not been any effort on it. But I'm not aware of that study or an outcome on it, but there is stuff going on in that market potential study that may be happening with folks that are more hands-on with it that I'm not aware of.
Okay. Going back to the time of use, you made a comment, and I want to make sure I have this understanding right. If someone were placed into what was previously known as the EV time of use, I think you called it day and night, or you changed the name of it in your testimony. You said that if they did nothing, they would still assume a 5% benefit or savings by going to that rate. Was that correct?
So there are individuals in that situation. So Mr. Keevil was directing me to a chart and some testimony that I'd filed in a prior case. And what we did is we looked at a sample of like 800 customers and figured out for each one what would their bill impact be. There were some customers that happened to fall into that bucket that they would have a 5% reduction. But if you were able to follow the testimony that I was looking at, you'd see that there was a distribution where customers, there were some that would save even more, and there were someone that would have higher bills. But the numbers that Mr. Keevil directed me to were for customers that would have savings, the savings that we discussed. That doesn't mean that that's, you know, the experience that everybody would have.
Have you modeled what would potentially be maximum savings if a sophisticated user were to do everything correct in terms of their timing and usage of a time of use rate? Do you have modeling that would show what the maximum savings could be?
I mean, I think that would really have to depend on the starting load profile of an individual customer. So I can't say that I've modeled specifically what is a maximum savings value that's theoretically possible, but it would be very different customer to customer, right? Because some folks who are already going to naturally save, they have additional savings potential, but it's not as big as somebody who's already a heavy peak period user. So there'd be a lot of variables that would go into such a study, but I don't think I can tell you a number that this is the theoretical maximum that somebody could save. But I will say, you know, individual customers can and have saved north of 20% on some of these rates.
Okay, the last question I have here, back to the net metering statute. You say you're sincerely interested in providing net metering customers with a time of use rate. Do you have any type of speculation on a time frame for when that might be available?
I mean, I think that, you know, one of our, you know, position as we've articulated is that, you know, it needs to be very clear whether it's statutory change. I know you talked about different interpretations of statute, but would need to be very clear that it's legal to net within time periods, and from our perspective, that has required statutory change. And the timeline, I mean, you probably know better than I do as a former senator what statutory, but there is the net metering task force that's going on this year that seems to us to be a potential opportunity for that to be, you know, introduced and contemplated by the legislature. And we certainly hope that that's, you know, that becomes an opportunity for that to happen and maybe address this issue.
Do do you have a position on Renew Missouri's request for you to conduct your own study on the time of use in the similar fashion that the previous rate case for another company in the state was required to do or asked to do?
So, I mean, my basic position is that we're pretty clear on what we think the barrier is. I mean, I think the way the Evergy study is to look at the billing and legal, and one of, I can't remember the other category of barriers. I think we know what we think the barrier is right now, and it's that legal provision of how netting occurs. Beyond that, I think we would expect to be able to, if we could net within, if there was clarity that we could net within time periods, I think that we would, be ready to offer net, time of use rates to net metered customers.
Okay. Thank you very much for your testimony and answering my questions. Thank you, Judge. I told you I'd be done by 5:30, and here we are. Thank you very much.
Thank you, Commissioner.
Hey, Judge, it's Commissioner Roop. I just had one quick comment regarding Commissioner Holzman's drafting of that legislation. I never thought I'd see the day where he was advocating for original intent of the lawmakers. And so, wow, this is a great day.
Thank you.
You're funny.
Okay, well, it's almost 5:30. As much as I hate to break up a witness, Mr. Wills, I'm going to ask you to be back here tomorrow. I've got a number of questions for you, and there may be some follow-up from the parties as well. So we will take that up tomorrow. Another thing I wanted to address, because I can't for the life of me remember. Hold on just a second. I cannot remember whether I said that the commission will take judicial notice or official notice of your direct testimony in ER-2022-0337, but we are an administrative body, so to clarify that, we're taking official notice of ER-2022-0337, your direct testimony. Is there anything else at this time that I need to take up before we adjourn until tomorrow? I see nothing. Why don't we, today was kind of a slow day, but I think we got through a lot of it. Why don't we take up tomorrow at 8:30? And with that, we will go off the record and recess until tomorrow at 8:30.
Thank you, Judge.